Oh, it didn't play the intro video. We're live now, everybody.
Oh, okay. I was like, waiting.
Play the
Hi, guys.
video. I don't know why, but you know what? That's okay. That's just how we do things around here. We just roll with it.
Is that what
So
you call the millennial pause? I don't know.
maybe it's the pregnant pause.
Ooh.
That one over there. Anyway, good afternoon, guys. Llama here with Annie. Good morning, Kelly B. I hope everyone had a great Easter. Me too. Mine was pretty chill. Got to hang out with my friends and have a good time. So I had a good weekend. Did you have a nice weekend, Annie?
Yeah, we didn't end up doing anything.
Oh,
Our plans changed somewhat last minute, so we just kind of chilled. Well, I did. My husband did a bunch of housework, so
did all the things. Well, that's kind of nice when you have and especially before baby. You guys can have just a chill holiday because after that, everyone's going to be like, why aren't you here? Where's the baby? We need to be here. Where's the baby?
It's our turn.
Yeah. So you guys get your last holiday of just the calm two of you. So that's nice. Well, you guys, so we're finishing up Lori today. Well, it's supposed to probably be finished up today. A few things because the court is kind of wonky today. And then we have to do time math with the time difference plus the 30-minute delay. So apparently the jury is getting there at 11, which is in 9 minutes. And then we have to wait 30 minutes. So 2:30, they're going to read the jury instructions. And then they're going to send them to lunch. I don't know why, but they are. So opening statements aren't going to start until 1 p.m. their time, so 4:30 our time. They'll do that. Hi, Terry. Hello. Welcome in. Welcome. So opening statements will start around 4:30. We'll listen to those. They did say that when a verdict comes in, instead of the 30-minute delay, there will be a 5-minute delay. So once we hear there's a verdict, it'll be about 35 minutes, and then they'll be live with that. Now, will they have a verdict today? What do you guys think? I think they're going to turn a quick verdict here. That's what I think.
I agree.
I mean, it doesn't look great for her. So, you guys, we have some exciting news. So, starting tomorrow morning at 8:30. I know last week I was on here. Okay, last week I was on here, and somebody asked, "Oh, Llama, are you going to cover Karen Reed?" And I said, "No. Are you crazy? I'm not going to cover Karen Reed. Do you think I wake up that early in the morning and talk to people? That's crazy. No, everyone knows. Don't talk to me till 10. Well, guess what? We're actually going to be moving over to True Crime and Wine Time, TCWT Media, starting tomorrow morning with a new show called Couch Court with Llama, where we're going to be streaming live the Karen Reed trial, and I'm going to be visited with different co-hosts each day. We're not lawyers, we're not legal experts, but we're avid true crime fans and trial watchers. So we're just like you. We're all just going to hang out like internet besties, on our couches with our snacks and watch what I've been told is going to be a very spicy trial. How many of you have watched the trial already? The first one. So we did not. Okay.
Yeah.
Me and Annie, we did not watch the first one. We did not get around to it. And so we don't really have an opinion. We've only heard our friends talking about it. So we don't really know. We know the basics, right? We know that allegedly Karen drops her cop boyfriend, John O'Keefe, off at a cop party house after the bar, and apparently backs into him and kills him and leaves him there dead in the winter time, and then took off. And apparently the investigation, I have been told that I'm going to have quite the reactions to this trial. Apparently the investigation is very shoddy, which is interesting because usually with a dead cop, you think that it would be well put together. Well, apparently is not. There's something about collecting evidence in red Solo cups, something about a dog. You know, but we have zero opinions, of whether she's guilty, not guilty, or what's going on. So I think it'll be a good time. What do you think, Annie? Are you excited about it?
I'm so excited. I've been trying not to dive too deep because I want
Sam.
the evidence to be presented to me with the jury.
Mm-hmm.
But I definitely looked up some timelines and got like a gist of what's going to come. So I'm excited.
I'm excited too. And everyone else is really excited for us. I know Buffy was like, I'm thinking about coming on just to watch your reaction the whole time.
I think she should.
Yes, I've been told that. Yeah. I've been told it's going to be something. So I have a feeling it's going to be a lot of eye rolling, a lot of snark. It'll be something. Now, how punctual I'm going to be at 8:30 in the morning, I don't know. All right. So we'll see. We'll get used to it. It'll be fine. But I'm so excited. Never thought I would be excited about a trial. I know, right? I'm very excited as well. And, very thankful for the opportunity to do this. So we'll see how it goes. We'll see how it all goes.
Hi, Terry.
Let's see. Was there anything else? Oh, so they had mentioned, because we didn't cover court on Thursday when they were meeting with jury instructions to go over them. We decided not to cover that because there wasn't really anything to that. And they read them all to the jury before they do closing arguments anyway. So we were just like, we'll just wait till today. Now, the next trial, she's supposed to start I forgot what her charge, the attempted assassination of her nephew-in-law, I guess is what you would call him, Brandon Bordeaux. That's supposed to start at the end of May. And Trina, the prosecutor, the judge is like, are you still going to need jurors for like a 6-week trial? And she was like, no, no, I think we can wrap it all up in the amount of time it took for this one, probably even less. And maybe, if Karen Reed is over, we might cover that one because Lori is expected to represent herself again. So that should be a fun time. And I think I want to say May 30th is the start of jury selection. So I don't think her jury selection took very long for this one. Though maybe the next one might be longer because I'm sure this is on their local TV, this trial. So maybe they might have a harder time getting a jury for her. But I wouldn't expect that to start anyway until June 5th would be my guess, especially if they're not doing court on Fridays.
Will that one also be in Arizona?
Yes. Yes. I think the same court and everything, which is convenient. Right? And I think if there's a verdict today, I don't think she's going to be sentenced today. So we'll have to come back and watch her sentencing. If we don't get a verdict today, you guys, tomorrow, if you join us over on the other channel, TCWT Media, True Crime and Wine Time, we will, during court break, we will watch the verdict if it comes in tomorrow. So if you follow us over there, you can catch the verdict, but I wouldn't be surprised if we get one today because they should be able to deliberate for like an hour and a half. So hello, Lady in Gray. Welcome. Welcome. Oh, and guess what? I'm getting tomorrow. Oh my gosh, I'm so excited. I got a new camera that came in today. So I'm going to look a lot better in the next 2 days. But I got this big green screen thing that like goes on my chair. It's kind of enormous. And I hope nobody comes over because it looks ridiculous. It looks very ridiculous. But then we don't have all this, disappearing, even though it's like a magic. And then I got an arm for my mic. and a quiet keyboard. Hopefully it's quiet, so I don't blow all that. You say guilty, Terry? I mean, yeah, I think they proved conspiracy, in my opinion. I would probably.
I think they finally got there. It took a minute, but they got there.
Yeah, I mean, it took the last two detectives for them to really establish that sort of evidence. Let's move on to Karen. I know everyone's super stoked for Karen, and I was talking last night. I was like, I think maybe they might be even more. By they, I mean the witnesses. From what I've heard, they're doozies. They're all characters, from what I've heard. But I'm curious how they'll be in the second trial. Like, I kind of feel like they might even be more catty or aggressive about having to do it again. So we'll see. I am ready for it. Oh, look at that. We got a seal up. So we'll be bringing that. Hi, Angie.
Hi, Angie.
Hope you're having a good day.
Hey, Sam.
Oh, yes. I'm going to need to take stock in the Red Bull and more coffee. I might just even move my coffee maker like right here by my desk or something.
I'm out of chai. Makes me sad.
Oh, no, that is sad. We got Lori in court. There's no sound yet. So we'll just put it on her. She's wearing a navy blue suit. Oh, they need new cameras. That's what they need. The speed is not great. Oh, and we're back to the seal again.
Okay.
I've been told in Karen Reed we don't have a seal. We just have a ceiling fan, I guess, that we're going to be big fans of. I don't know. We'll see.
Okay. Hi, Polly Pie.
Oh, hey, Polly. Welcome.
OnlyFans.
Oh, we got sound.
All right, we're on the record. State of Arizona versus Lori Daybell, CR 2021-001-704. Why don't I have the state announce? And the defendant?
Lori Daybell.
Lori Daybell.
All right, we met on Thursday and went over jury instructions. In the meantime, since Thursday, there was a few modifications sent out. We put drafts on your desk this morning. Last week, let me just pull up that email.
Okay. Yay, Polly's almost home. I didn't see Amos in here. Oh, that's not Amos. There she is.
Last week, the state requested some modifications that were made, and then on Friday,
That happened. It's a party.
Advisory Council also requested a correction to the presumption of innocence, which I did do, as well as a mere presence instruction. Does anyone want to make a record on any of those changes that have occurred since we met Thursday? I forgot, I don't know if my staff told you, I did add, I realized standard number 9 was not added, which is defendant need not produce evidence. So I added that this morning as well. Have you had a chance to review the latest draft, or do you need more time? We told the jurors to be here at 11, so we have time if you need more time.
Okay. Well, there's that so far. Oh, so there's 14 jurors, by the way. 2 women and 12 men. So I don't think that's going to be chair. Okay, gosh, it's so dark. I need to work on the lighting. I need to work on the lighting. I have like all the lights on, and I'm still so dark.
That's funny.
Any other record you want to make on mere presence? All right, has the defendant had a chance to review the final instructions?
Yes, Your Honor.
Any additions or corrections?
No, Your Honor.
All right, we're still waiting for a few jurors to show up. The plan this morning, well, let me ask the defendant, you still plan on resting?
I do.
Okay, so when the jury comes in,
Boo.
I'll
Boo.
remind them
Boo,
of
boo
the rest
you.
of last Wednesday, and then I'll turn to you and you'll presumably say the defense rests. I'll read the jury instructions and we will break after I read the jury instructions. Depending on what time we break, I'll tell them what time to come back for the closing arguments, approximately an hour later or around 1 p.m. While we're waiting, I had my staff email the parties about any potential aggravators. I didn't see a response to that. So in addition to, if there is a second phase of this trial for aggravation, in addition to a dangerous finding, does the state know what other aggravators it might be pursuing? Anything else? Okay. And in the event that happens, would you be producing testimony or evidence, or would it just be argument? Okay. All right. So how many jurors? You can go ahead and print out.
Your Honor, I have 2 issues I'd like to bring up real quick.
Of course.
The jury process of the jury alternate selection. Can you tell me what that process is going to be today?
It's literally drawing 2 numbers out of randomly out of a container.
Okay. And when is that going to be done and how does that
Not
work?
till after the closing arguments.
Okay.
So the alternates are told that they're still alternates. They're not released because I have had in the past jurors become sick or ill or not be able to deliberate, and we have to call back an alternate to deliberate. So they're still under the admonition until they're released.
So we're keeping all of them, basically.
But only 12 will go back and deliberate.
Okay.
If one of those 12 becomes sick or is unable to deliberate, we would bring in an alternate and release the person that can't deliberate. Does that make sense?
Yes.
All right, what else?
So it came to my attention this weekend that the exhibit number 286 that the state put into evidence that Detective Inkland testified to was the full interview is only about 21 minutes long, and the actual interview is about 55 minutes long.
Remind me what's 286?
Yeah, you're just
Whose
like
interview?
sitting in there.
It's my interview, I guess, with Detective Inkland.
I think that's been redacted because the full interview wouldn't be admitted into evidence for the jury to review. Is that correct? All right.
So is it just the snippets that were played all together?
It should just be the parts that were played in court. Is that correct?
That's how.
All right.
I'm not sure what they meant by a second phase. Maybe they mean like phase that, this and then phase 2 sentencing, maybe?
Right.
Maybe.
I'm not sure.
So did you have a question about that?
Yes. So is it just the snippets all put together, or is it the interview for the first 21 minutes?
I think it's just the snippets that were played in
Yeah, I
court
think that's what
that
it
are
might
put
be.
together as one exhibit. Right, portions have been redacted out.
Talking to Mike,
But
Trina.
it's just more or less what was played during testimony. Does that answer your question?
Kind of, but Detective Inkland testified that it was the full interview. So what does that mean if she's testified that it was the full interview?
I don't know. It's something you could have cross-examined her on, but now it's probably too late. If you wanted clarification on that, but the jury is going to know it's redacted, and they get the redacted exhibits instruction as part of the instructions. So either side can point that out to the jury that it's redacted. Anything else?
I was just assuming that that might have been an error to say that it was the full interview when it wasn't the full interview, and it was admitted into to reflect the record that it was the full interview. So are you telling me that the jury is not going to be able to go back and watch the full thing?
Your full interview?
Correct.
No, because it was never admitted into evidence.
But that's what they said was admitted into evidence.
I don't remember if that's what was said or not. I would be surprised if someone said your entire interview was being admitted, but I don't remember the exact
My
testimony.
advisory counsel checked the FTR, and that's exactly what was said. That was exactly what I was shown, that it said, is this the full interview? Yes, this is the full interview, and it was admitted into evidence.
Was there sometimes they enter in the full interview for appeal purposes only, but that's not the one that actually gets shown to the jury. Was that the case?
Was not for
Okay.
Hmm.
full interview. The defendant talks to the detective in the beginning about Kylie, does not do that. She talks to the detective at the end about Kylie and kitchen services. It doesn't include any of that. She's sitting at right over how long more Kylie's been interviewed. It doesn't include any of that. This interview about what happened.
Okay.
Senator Tiley stuff.
So the states closed their evidence.
I'm just trying to find out what the jury is going to be seeing. They have all that evidence in the evidence when they deliberate. Is that correct? They
Whatever
have
was
access to that.
whatever was admitted into evidence, which portions of your interview were not admitted into evidence, it sounds like.
Okay, but from what I'm understanding from the state, just correct me if I'm wrong, it's not just the snippets that were played, but it's a partial part of the interview, and some of it was redacted. Is that correct?
That's what I'm understanding. The parts regarding what Tylee said or did or didn't happen, the hearsay parts were the start and the end were redacted out.
And then what was meant by the testimony that this is the full interview?
I don't know. I guess that's something that someone could have asked that witness.
Maybe if you had a lawyer. Probably would help.
Maybe it was the full interview of your version of what happened.
So we have
There.
our exhibit 20, the defense's proposed exhibit 20 is the full interview. Can we replace that one with the full interview since it was entered into evidence as the full interview?
Nobody's gonna watch.
Why not?
Right.
Your full interview won't come in because it's a significant amount of hearsay within that interview that's not admissible evidence.
Because, you know,
It was admitted as
your
the
daughter's
full
dead.
interview.
Well, if
So-
the witness
Should have got a
testified that it was
lawyer.
a full interview, either side could have clarified that with that witness. I don't know what that witness meant when they said that.
Okay.
Anything else?
That's it.
Oh,
All right.
That's
We're
it.
getting the sufficient number of the jury instructions copied. As soon as that's done and our jurors get here, we'll read those instructions.
I forgot. The state said they were going for the death penalty.
are they? I mean, I see the comments here. I was waiting until afterwards
I'll have to look. I'll look it up because I don't remember.
because it could be different in different states. I know here in my state, when it's a death penalty, they usually have to state it as before trial. And this is in my state. Different states vary. So it very well could be the case in Arizona. I don't know. I just know when we have death penalty trials, like you have to, it's the same jury to find them guilty or not guilty, and it's the same jury for the death penalty sentencing because they have to be a death qualified jury. And usually with death qualified juries, like they ask specific questions like, can you possibly, if all of the evidence by law, you had to vote this way, could you do that? So, hold on, my mic's being finicky.
You sound super clear to me.
All right, we'll see. Is that better for anyone?
It sounded super clear to me earlier.
Okay. Well, I did knock it over earlier this morning when the internet guy was here. So sometimes that messes it up. But yeah, I mean, if somebody wants to look and see if this is a death penalty, again, they could do it differently where they first find, someone guilty or not guilty and then do a different one. I have heard of that before.
Just over here munching on my snacks.
Oh, what did you guys bring for snacks today? I got the rest of my gummy bears. I'm like, oh, well, it's green, so it's just going to disappear. Hold on. There we go. I only have a little bit left. I'm going to need to go snack shopping after court tomorrow.
I made we're going to call it a charcuterie board.
A court charcuterie. Terry's eating ribs and potato salad. Oh my goodness.
Ribs is what we had ribs last night for dinner, and Brent made so much that we're having it for lunch and dinner today.
That's great. Leading Gray's eating popcorn, cheese, and crackers. Nice.
We're doing strawberries, apples, and cheese.
Y'all are too healthy.
Doctor was like, you should eat a protein with whenever you eat a sugar or carb. And I was like, can do. Does cheese count? It does.
So Lady in Gray says, what have I missed? My son and his fam just left. So they're about to read jury instructions here in like 15 minutes. That's all they were, just going over stuff. And then they're going to read them jury instructions. Then they're going to dismiss the jurors to lunch. So opening statements aren't going to start until 4:30 our time. So we'll probably watch jury instructions for a little bit, and then we're probably going to take a break and come back at like 4:15, so we don't miss closing statements. So I think it's kind of silly. I think as a juror, I would be annoyed if you told me to come in late and then I sat there for 20 minutes and then it was lunch. I would just be like, can we just power through? It's so late in the day. But I mean, I get it. Staff need to eat too, I suppose. But
I suppose.
Now you're hungry. What's wrong with this judge? Doesn't he know we're streaming this? I mean, I know, right? Think of us, please. The camera guy listens to us. He's been great. No. Okay.
I don't see where the state is going for the death penalty.
Well, I'm curious if they even could, right? I don't know if conspiracy counts because she for some reason, and which I am confused in. All right. So let's say they find her guilty of conspiracy to murder. Why is she not being charged with felonious murder?
I was talking about that the other day.
The conspiracy clearly resulted in a murder. So I don't really understand why that choice was made. I'm sure it was brought up in one of the pretrial motions that we didn't do. She said a second phase. That's true, but I think that could just be sentencing, right? That's not uncommon for it to call that. But we'll see. Oh, we'll start after this. Are they going to directly sentence her? Some courts do. Some courts, as soon as you're found guilty, they're like, we're doing sentencing now. Others, they usually require like an special investigation, if you will, for mitigating factors, and then sentencing can sometimes be like a month later. So, but I feel like, because this is the same court as Hannah, what's her name, from the Rust shooting, Hannah Gutierrez, I think was her name, Gutierrez. I think her sentencing was like the next day. So, you're bringing back witnesses? All right, Cam. All right. We'll see. We'll see.
I don't, if it could have been, I mean, if it was the death penalty, there's no way that I would be representing myself.
No way. No way. I mean, it's a ballsy move if that's the case. But, and I'll be honest, even if they were going for death penalty, I don't know if this would be a strong enough case to be able to bring death, just because so many people are dead. You know what I mean? So Texas usually does sentencing right away, Belle says. Yeah, we don't do that here in my state. They do a BMI report or something. I know Wisconsin does that as well. I've watched plenty of Wisconsin trials. But I've seen some where they're just like, oh, guilty? All right, let's start. Like, oh, okay. Sentencing reports can be prepared beforehand. I mean, I would think, but we'll see. Because I don't know how many years she's facing for conspiracy. I haven't looked into that. Now, what do you guys think? So she's been convicted in Idaho of the deaths of Tylee, JJ, and Tammy. She's serving life without parole there. And so if she does get found guilty and sentenced here, is she going to fulfill her Arizona time and then go back to Idaho?
I would think they would tack it on. Yeah.
They would probably just like move all the sentencing to Idaho, like have a dual, because you can do that, right? Like you can.
Yeah, I mean, that would probably be easier.
I don't know. I don't know how that works. I'm surprised they haven't even moved. Oh, well, they can't move Chad out because he got the death penalty, so never mind. I know some high profile cases, they'll actually move the defendant to a whole different state in prison because less people know them there. Like, George Wagner IV got sent out of Ohio to somewhere else. And I think I heard Daryl Brooks too, but I don't know about that. Let's see. We got some comments here. She'll go back to Idaho, and if something happens in Idaho, clemency shall be sent to Arizona to serve. I think that makes more sense, right? Does Arizona reimburse Idaho for that? I believe so. Only based on the Wagner case that I know of. So like we shipped George Wagner out of Ohio to a different prison, but like Ohio still foots the bill, right? If that makes sense. Daryl Brooks is somewhere else. Okay. Everyone knows Lori. She can't hide. I mean, how do you hide a multidimensional goddess? She has no bounds. I think it's strange they move them to prisons in other states. I mean, I think it's strange too. Some states don't have that many prisons. We have like 4.
Oh, I got to look it up now. I don't know how many North Carolina has.
I think we have like 4 men's prison and then just like 1 women's prison. Oh, I guess I can not I can make us decently sized.
Are you saying that
Oops, sorry.
you only have like 5 state prisons?
4. Well, yeah, 5 total. I think 4 men and 1 women prison.
So we have 5 federal prisons and 1 federal prison camp in the state, but we have 53 state prisons.
Holy crap. What? WTF? Okay. Oh, you know what, Terry? I got some of those in my bedroom. I'm going to get those during the break.
So my family, except my mom, who's amazing and agrees with me, my family loves Reese's.
Mm-hmm.
But my mom and I both love peanut butter and chocolate separately, but together it's the worst combination. I know. I hate
All right,
Reese's.
everybody.
I think it's
canceling the show. We're done.
yeah,
here.
done. Annie's gone.
We don't care about Annie's opinions anymore, clearly.
I think it's all the extra sugar they put in the Reese's. Because like sometimes I can do the peanut M&Ms, not peanut butter M&Ms, the peanut M&Ms.
These are like all my favorite things.
Cancel
Annie. We've been on for like a week and canceled already. You have 50 state prisons? Oh my goodness. Okay.
Wow.
Well,
I don't know what we're doing in the South.
He's fired. Bill says in over 100 state prisons, jails. Yeah, each county has a jail. We have 88 counties. But are yours guys just not like that big or something? Or like what is happening?
Now we're going to see how many county jails we have.
Cam is in New York. Well, welcome from New York, Cam. Prefer the eggs over the cups. You know what? Can I just rant about these Reese's eggs? Back to the Reese's eggs. So Elbow Feet brought home a bag from Easter yesterday. And I kid you not, the eggs are way smaller than what they used to be. Okay? I know I'm not crazy. I know they used to be bigger than that. And now they're like bite-sized eggs. And they don't say many at all. This shrinkflation is getting out of control. You have a state jail. Oh, okay. That's interesting.
We have 93 counties and 109 county jails.
You have 3 state prisons in just East Tennessee? Wow.
Ohio's on some good behavior.
I'm thinking it's good that we only have a few, but you know, the important topic. Exactly. The Reese's eggs. You know what? Crap. I'm going to have to elbow feet off the store because you know what? I didn't buy it all. Starburst jelly beans. I know.
That's the best candy.
I know. They've been out for like 2 months and I haven't got around to it.
I haven't had any this season either.
Oh, see here, like if you only go to prison usually if you're serving over a year. Otherwise, you do your time in county is usually how they do that here. So they have 2 sizes. I understand that they have 2 sizes, but they didn't used to have 2 sizes. Okay. And now we're just supposed to accept it. There was one reasonable size and I'm not happy about it. Buffy, they have a rodeo at their prison. That is true. A prisoner rodeo they put on twice a year, if I remember right. And I want to go. Yeah, like the prisoners, like it's a whole to do, like it's a family thing. It's the wildest thing. Yes, it's wild. Prisoners, like, you know, there's bowls.
That is the most Southern thing I think I've ever.
I want to go. It sounds awesome. It's a very big deal there. And apparently, you know, they love it.
The only way to get you to go to Louisiana.
Right, the only way. A federal prison. I don't know if we have any federal ones in Ohio. Maybe. Let's see. Try the Reese's chocolate rabbits. No, didn't know that was a thing.
You shouldn't have to. Why would you do that to yourself?
You guys have prison rodeos too in Texas? That is so, you Southerners. I can't even with you guys.
I gotta look up. Hold on. Prison radio. What is gonna pop up on my
Angola.
phone?
It's Angola, if I remember right. It's a real thing. And it's like the family day. It's like bring the kids. It's a whole event. They got vendors and everything. Did we not see Urban Cowboy? Oh, I never watched Urban Cowboy, and I know what it is. Annie definitely doesn't know what it is, but I haven't watched it.
North Carolina does not participate in prison radios.
Oh,
We're just not that
okay.
southern.
Well, if we're housing them, we should get some entertainment out of it. It's all voluntary. That's true. They very much enjoy it. So, hair noises.
All right, we're back on the record. State of Arizona versus Daybell, CR 2021-001704. The parties are present. The jury is not present. We'll bring in the jury.
This guy seems like he is just so over this.
I'll add it to the list of things I have to educate myself on.
That's true. I can't believe there's 2 women and 12 men. It's pretty interesting. I don't think that's going to look good because Charles sounds like a real stand-up guy. So.
The jury is present. Welcome back, members of the jury. Last Wednesday afternoon, the state rested its case, so now I'll turn to the defendant.
The defense also rests, Your Honor.
All right, at this time, that concludes the evidence portion of the trial. I'm going to have my staff hand out to the jury the final jury instructions.
You had more to give, Lori. We deserved
Such a
better.
disappointment. Too. If I have to watch Wars Star, for Pete's sake, Terry, you're killing me, Smoss. You're killing me. I have to watch Urban Cowboy. Wars Star. Oh, my goodness. I love you so much, Terry. I love you.
Are we one? No, we got it. Okay. Jurors have the instructions. Much like the preliminary instructions, you can either follow along with me or just listen. I need to read these into the record. Duty of jury. It is your duty as a juror to decide the case by applying these jury instructions to the facts as you determine them. You must follow these jury instructions. They are the rules you should use to decide this case. It is your duty to determine what the facts are in the case by determining what actually happened. Determine the facts only from the evidence produced in court. When I say evidence, I mean the testimony of witnesses and the exhibits introduced in court. You should not guess about any fact. You must not be influenced by sympathy or prejudice. You must not be concerned with any opinion that you feel I have about the facts. You, as jurors, are the sole judges of what happened. You must consider all these instructions. Do not pick out one instruction or part of one and ignore the others. As you determine the facts, however, you may find that some instructions no longer apply. You must then consider the instructions that do apply together with the facts as you have determined them. Evidence to be considered. You are to determine what the facts in the case are from the evidence produced in court. If the court sustained an objection to a lawyer's question, you must disregard it and any answer given. Any testimony stricken from the court record must not be considered. Rulings of the court. Admission of evidence in court is governed by rules of law. I have applied those rules during the trial and resolved any issues concerning the admission of evidence. If an objection to a question was sustained, you must disregard the question and you must not guess what the answer to the question might have been. If an exhibit was offered into evidence and an objection to it was sustained, you must not consider that exhibit as evidence. If testimony was ordered stricken from the record, you must not consider that testimony for any purpose. If evidence was admitted for a limited purpose, you shall consider that evidence only for that limited purpose. Do not concern yourselves with the reasons for my rulings on the admission of evidence. Do not regard those rulings as any indication from me of the credibility or weight you should give to any evidence that has been admitted. Direct and circumstantial evidence. Evidence may be direct or circumstantial. Direct evidence is the testimony of a witness who saw, heard, or otherwise sensed an event. Circumstantial evidence is the proof of a fact or facts from which you may find another fact. The law makes no distinction between direct and circumstantial evidence. It is for you to determine the importance to be given to the evidence regardless of whether it is direct or circumstantial. Redacted exhibits. Some of the exhibits that have been admitted into evidence have had portions deleted from them for legal reasons. Do not concern yourselves with the reasons why some portions of the exhibits have been deleted. Do not speculate upon what the deleted portions might or might not reveal. Indictment is not evidence. The state has charged the defendant with a crime. A charge is not evidence against the defendant. You must not think a defendant is guilty just because of a charge. The defendant has pled not guilty. This plea of not guilty means that the state must prove each element of the charge beyond a reasonable doubt. Self-represented defendant. The defendant in this case represents herself. All instructions I read to you that include references to lawyers or attorneys apply equally to the defendant's self-representation at trial. The defendant's decision to represent herself should not be considered by you when determining the facts. Comments are not evidence. In their opening statements, the prosecutor and the defendant talk to you about the law and the evidence. In a few minutes, the prosecutor and defendant will give their closing arguments and will talk about the law and the evidence. What they said or say is not evidence because it is not sworn testimony, but it may help you to understand the law and the evidence. Credibility of witnesses. In deciding the facts of this case, you should consider what testimony to accept and what to reject. You may accept everything a witness says or part of it or none of it. In evaluating testimony, you should use the tests for truthfulness that people use in determining matters of importance in everyday life, including such factors as the witness's ability to see or hear or know the things the witness testified to, the quality of the witness's memory, the witness's manner while testifying, whether the witness had any motive, bias, or prejudice, whether the witness was contradicted by anything the witness said or wrote before trial or by other evidence, and the reasonableness of the witness's testimony when considered in the light of the other evidence. Consider all of the evidence in the light of reason, common sense, and experience. Testimony of law enforcement officers. The testimony of a law enforcement officer is not entitled to any greater or lesser importance or believability merely because of the fact that the witness is a law enforcement officer.
Oh, I hope they have that
You are to
instruction,
consider the
Karen
testimony
Reed.
of a police officer just as you would the testimony of any other
Yep.
witness. Expert witness. A witness qualified as an expert by education or experience may state opinions on matters in that witness's field of expertise and may also state reasons for those opinions. Expert opinion testimony should be judged just as any other testimony. You are not bound by it. You may accept it or reject it in whole or in part, and you should give it as much credibility and weight as you think it deserves, considering the witness's qualifications and experience, the reasons given for the opinions, and all the other evidence in the case. Defendant need not produce evidence. The state must prove guilt beyond a reasonable doubt based on the evidence. The defendant is not required to produce evidence of any kind. The defendant's decision not to produce evidence is not evidence of guilt. Defendant need not testify. The state must prove guilt beyond a reasonable doubt based on the evidence. You must not conclude that the defendant is likely to be guilty because the defendant did not testify. The defendant is not required to testify. The decision on whether or not to testify is left to the defendant. You must not let this choice affect your deliberations in any way. Mere presence. Guilt cannot be established by the defendant's mere presence at a crime scene, mere association with another person at a crime scene, or mere knowledge that a crime is being committed. The fact that the defendant may have been present or knew that a crime was being committed does not in and of itself make the defendant guilty of the crime charged. One who is merely present is a passive observer who lacked criminal intent and did not participate in the crime. Voluntariness of defendant's statements. You must not consider any statements made by the defendant to a law enforcement officer unless you determine beyond a reasonable doubt that the defendant made the statements voluntarily. A defendant's statement was not voluntary if it resulted from the defendant's will being overcome by a law enforcement officer's use of any sort of violence, coercion, or threats, or by any direct or implied promise, however slight. You must give such weight to the defendant's statement as you feel it deserves under all the circumstances. Jury not to consider penalty. You must decide whether a defendant is guilty or not guilty by determining what the facts in the case are and applying these jury instructions. You must not consider the possible punishment when deciding on guilt. Punishment is left to the judge. Presumption of innocence, burden of proof. The law does not require a defendant to prove innocence. Every defendant is presumed by law to be innocent. You must start with the presumption that the defendant is innocent. The state has the burden of proving the defendant guilty beyond a reasonable doubt. This means the state must prove each element of each charge beyond a reasonable doubt. In civil cases, it is only necessary to prove that a fact is more likely true than not, or that its truth is highly probable. In criminal cases such as this, the state's proof must be more powerful than that. It must be beyond a reasonable doubt. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find her guilty. If, on the other hand, you think there is a real possibility that she is not guilty, you must give her the benefit of the doubt and find her not guilty. Evidence of any kind. The state must prove guilt beyond a reasonable doubt on the evidence. The defendant is not required to produce evidence of any kind. The decision on whether to produce evidence is left to the defendant. The defendant's decision not to produce any evidence is not evidence of guilt. Voluntary act. Before you may convict the defendant of the charged crime, you must find that the state proved beyond a reasonable doubt that the defendant committed a voluntary act. A voluntary act means a bodily movement performed consciously and as a result of effort and determination. You must consider all the evidence in deciding whether the defendant committed the act voluntarily. Absence of other participant. The only matter for you to determine is whether the state has proved the defendant guilty beyond a reasonable doubt. The defendant's guilt or innocence is not affected by the fact that another person or persons might have participated or cooperated in the crime and is not on trial now. You should not guess about the reason any other person is absent from the courtroom. Motive. The state need not prove motive, but you may consider motive or lack of motive in reaching your verdict. The charged offense. I will now tell you about the crime with which the defendant is charged. Count 1, conspiracy to commit first-degree murder. The crime of conspiracy to commit first-degree murder requires proof that the defendant, on or about July 11, 2019, with the intent to promote or aid in the commission of first-degree murder, agreed with Alexander Cox that at least one of them or another would engage in conduct constituting the offense of first-degree murder. The crime of first-degree premeditated murder requires proof that a person, 1, caused the death of another person, and 2, intended or knew that he or she would cause the death of another person, and 3, acted with premeditation. Premeditation means that the defendant intended to kill another human being or knew she or a co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. An act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. The time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. Elements of conspiracy. The crime of conspiracy to commit first-degree murder requires proof. 1, the defendant agreed with one or more persons that one of them or another person would engage in certain conduct, and 2, the defendant intended to promote or assist in the commission of such conduct, and 3, the intended conduct would constitute the crime of first-degree murder, and the defendant knew that such conduct was a crime. Scope of proof of conspiracy. To prove a conspiracy, it is not necessary to show a formal meeting or an express agreement. A conspiracy may be inferred from circumstances showing a common criminal objective and does not require proof that all means set forth in the charging document were agreed upon or actually used, nor that every person involved was a member of the conspiracy. Proof of membership in conspiracy. One may become a member of a conspiracy without full knowledge of all the details of the conspiracy. On the other hand, a person who has no knowledge of a conspiracy but happens to act in a way that furthers some object of the conspiracy does not thereby become a conspirator. Before you find that a defendant or any other person was a member of a conspiracy, the evidence must show beyond a reasonable doubt that the conspiracy was knowingly formed and that the defendant or another person knowingly participated in the unlawful plan with the intent to promote or assist the carrying out of the conspiracy. One who knowingly joins an existing conspiracy is as responsible as an originator or instigator of the conspiracy. A person understanding the unlawful character of a plan who knowingly encourages, advises, or assists in the undertaking thereby also becomes a conspirator. In determining whether a conspiracy exists, you should consider the actions and statements of all the alleged participants. However, in determining whether a particular defendant was a member of the conspiracy, you should consider only that person's acts and statements. A person cannot be bound by the acts or statements of other participants until it is established that a conspiracy existed and that person was one of its members. Justification for self-defense physical force. A person is justified in using or threatening deadly physical force in self-defense if the following two conditions existed. One, a reasonable person in the situation would have believed that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force. And two, the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in the situation. A person may use deadly physical force in self-defense only to protect against another's use or apparent attempted or threatened use of deadly physical force. Self-defense justifies the use or threat of deadly physical force only while the apparent danger continues, and it ends when the apparent danger ends. The force used may not be greater than reasonably necessary to defend against the apparent danger. The use of deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate deadly physical danger appeared to be present. Actual danger is not necessary to justify the use of deadly physical force in self-defense. You must decide whether a reasonable person in a similar situation would believe that deadly physical force was immediately necessary to protect against another's use, attempted use, threatened use, apparent attempted use, apparent threatened use of unlawful deadly physical force. You must measure the person's belief against what a reasonable person in the situation would have believed. A person has no duty to retreat before threatening or using deadly physical force in self-defense if the person, one, had a legal right to be in the place where the use or threatened deadly physical force in self-defense occurred, and two, was not engaged in any unlawful act at the time when the use or threatened deadly physical force in self-defense occurred. If evidence was presented that raised this justification defense for count one, conspiracy to commit first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the defendant or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Justification for defense of a third person. A person is justified in using or threatening physical force in defense of a third person if the following two conditions existed. One, a reasonable person in the situation would have believed that physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. And two, the defendant used or threatened no more physical force than would have appeared necessary to a reasonable person in the situation. A defendant may use deadly physical force in defense of a third person only to protect against another's use, attempted use, apparent attempted use, threatened use of deadly physical force. Defense of a third person justifies the use of or threat of physical force or deadly physical force only while the danger continues, and it ends when the danger ends. The force used may not be greater than reasonably necessary to defend against the danger. Actual danger is not necessary to justify the use of physical force or deadly physical force in defense of a third person. The use of physical force or deadly physical force is justified if a reasonable person in the situation would have reasonably believed that immediate physical danger appeared to be present. You must decide whether a reasonable person in a similar situation would believe that, one, Physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person, and or 2, deadly physical force was necessary to protect against another's use, attempted use, apparent attempted use, threatened use of unlawful physical force against a third person. You must measure the person's belief against what a reasonable person in the situation would have believed. The state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Use of force in crime prevention. A person was justified in threatening or using physical force and or deadly physical force against another if and to the extent the person reasonably believed that physical force or deadly physical force was immediately necessary to prevent another from committing or apparently committing the crime of aggravated assault. There is no duty to retreat before threatening or using deadly physical force. There is no requirement that any threat to the person's safety exists before the person may use physical force and or deadly physical force. However, physical force and or deadly physical force can be used only to the extent it appears reasonably and immediately necessary to prevent commission of the crime of aggravated assault. The person's use or threatened use of physical or deadly force is not limited to a person's home, residence, place of business, land the person owns or leases, or conveyance of any kind, but includes any place in this state where a person has a right to be. The person is presumed to have acted reasonably if the defendant reasonably believed he or she was acting to prevent the imminent or actual commission of aggravated assault. The person is justified in using physical force and or deadly physical force against another person, even if that person is not actually committing or attempting to commit the crime, if the person reasonably believed he or she was preventing the commission of the crime. Actual danger is not necessary to justify the use of physical force or deadly physical force in crime prevention. If evidence was presented that raised this justification defense for first-degree murder, then the state has the burden of proving beyond a reasonable doubt that the person did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Non-justification for threat or use of physical force. A person is not justified in using or threatening physical force against another in response to verbal provocation alone, or if the defendant or co-conspirator provoked the other person's use or attempted use of unlawful physical force, unless 1, the defendant or co-conspirator withdrew from the encounter or clearly communicated to the other person the intent to withdraw with the reasonable belief that the defendant could not safely withdraw, and 2, the other person continued or attempted to use unlawful physical force against the defendant or co-conspirator. The state has the burden of proving beyond a reasonable doubt that the defendant and or co-conspirator did not act with such justification. If the state fails to carry this burden, then you must find the defendant not guilty of the charge. Definitions. Intentionally or with the intent to means that a person's objective is to cause that result or to engage in that conduct. Intent may be inferred from all the facts and circumstances disclosed by the evidence. It need not be established exclusively by direct sensory proof. The existence of intent is one of the questions of fact for your determination. Knowingly, willfully, or knew means that a person is aware or believes that his or her conduct is of that nature or that the circumstance exists. It does not require any knowledge of the unlawfulness of the act or omission. If the state is required to prove that the defendant acted knowingly, that requirement is satisfied if the state proves that the defendant acted intentionally. A defendant is criminally accountable for the conduct of another if the defendant is an accomplice of such other person in the commission of the offense, including any offense that is a natural and probable or reasonably foreseeable consequence of the offense for which the person was an accomplice. Accomplice means a person who, with the intent to promote or facilitate the commission of the offense, does any of the following. 1, solicits or commands another person to commit the offense, or 2, aids, counsels, agrees to aid, or attempts to aid another person in planning or committing the offense, or 3, provides means or opportunity to another person to commit the offense. Act means a bodily movement. Aggravated assault means a person intentionally, knowingly, or recklessly caused a physical injury to another person or intentionally put another person in reasonable apprehension of imminent physical injury by either 1, causing serious physical injury to another person, or 2, using a deadly weapon or dangerous instrument. Conduct means an act or omission and its accompanying culpable mental state. Deadly weapon means anything designed for lethal use, including a firearm. Dangerous instrument means anything that is readily capable of causing death or serious physical injury under the circumstances in which it is used, attempted to be used, or threatened to be used. Deadly physical force means either 1, force which is used with the purpose of causing death or serious physical injury, or 2, force which in the manner of its use is capable of creating a substantial risk of causing death or serious physical injury. Unlawful means contrary to law, or where the context so requires, not permitted by law. Jury foreperson. The case will soon be submitted to you for your decision. When you go to the jury room, you will choose a foreperson. The role of jury foreperson is important, but please remember that the foreperson's opinion about the case is not more important than that of the other jurors. The opinions of each juror count equally. The jury foreperson's responsibilities include the following. 1, make sure every member of the jury is present during all discussions and deliberations. 2, make sure that the deliberations are conducted respectfully and that all issues are fully discussed. The discussions should be open and free so that every juror may participate. 3, all jurors should be allowed to state their views about the case and what they think the verdict should be and why. 4, all members must agree unanimously on any verdict. Therefore, the foreperson should count the votes to ensure that every juror has voted. 5, if you reach a verdict, fill out the verdict form and then sign the form on behalf of the jury. 6, if the jury reaches a verdict, the foreperson will inform the courtroom assistant. When the jury returns to the courtroom, the foreperson will bring the signed or unsigned verdict form as well as any question forms that may have been used. 7, when you return to the courtroom, the court will ask the foreperson whether the jury has reached any verdict. The foreperson will respond yes or no. The foreperson is not expected to read any verdict to the court. That will be done by the clerk. Closing instruction. In a few minutes, we're probably going to take a lunch break, and then after the lunch break, you will hear the closing arguments in this case. After that, the case will be submitted to you for decision. I suggest that you discuss and then set your deliberation schedule. You are in charge of your schedule and may set and vary it by agreement and the approval of the court. After you have decided on a schedule, please advise the courtroom assistant. You are to discuss the case and deliberate only when all jurors are together in the jury room. You are not to discuss the case with each other or anyone else during breaks or recesses. The admonition I have given you during the trial remains in effect when all of you are not in the jury room deliberating. After setting your schedule, I suggest that you next review the jury instructions and verdict form. It may be helpful for you to discuss the instructions and verdict form to make sure that you understand them. Again, during your deliberations, you must follow the instructions and refer to them to answer any questions about applicable law, procedure, and definitions. Should any of you or the jury as a whole have a question for me during your deliberations or wish to communicate with me on any other matter, please utilize the jury question form that we will provide you. Your question or message must be communicated to me in writing and must be signed by you or the foreperson. I will consider your question or note and consult with counsel before answering it in writing. I will answer it as quickly as possible. Remember that you are not to tell anyone, including me, how you stand numerically or otherwise until after you have reached a verdict or have been discharged. During your deliberations, you must not communicate with or provide any information to anyone by any means about this case. You may not use any electronic device or social media to communicate to anyone any information about this case or to conduct any research about this case until I accept your verdict. All 12 of you must agree on the verdict. You must be unanimous. Once all 12 agree on a verdict, only the foreperson needs sign the verdict form on the line marked jury foreperson. You will be given one form of verdict. The verdict form reads as follows, and there is no significance to the order in which the options of guilty or not guilty are listed on the verdict form. So this is a sample verdict form at the end of your instructions. It indicates this is a sample. An official verdict form will be given to you by the courtroom assistant in the jury room. Verdict: count 1, conspiracy to commit first-degree murder. We, the jury, duly impaneled and sworn in the above entitled action and upon our oaths, do find the defendant, Lori Daybell, as to the crime of conspiracy to commit first-degree murder occurring on or about July 11, 2019 as follows. Check only 1, and the options are not guilty or guilty. In order to break up the closing arguments as little as possible, we're going to take our lunch recess a little early and start a little early with those closing arguments after you recess. So we'll go ahead and recess for your lunch break. If we could have everyone ready to go in the jury room at 12:45.
Ooh, okay.
Please remember the admonition.
Okay.
So that'll be 4:15 our time. Because she keeps you constantly pissed off. Yeah, I mean, listen, all right, jury instructions are a bore. Okay. Especially, I mean, that was quick. All right. Daryl Brooks had 72 charges, and I think reading the jury instructions was like an hour and a half.
Yeah.
But the jury instructions are very, very important with how they word things. You know, it's not as simple as, you know, just checking guilty or not guilty. You know, a classic example of why jury instructions matter and charges matter is the Casey Anthony case. You know, like that's a textbook example of a state overcharging and what it said for them to find in the jury instructions didn't match up.
All right. Anything else from the state? Defense?
Your Honor, can I move for Exhibit 20 to be admitted for appellate purposes?
Is that your full interview?
Yes.
Oh my.
Any objection? All right. Exhibit 20 would be admitted for appeal purposes. It won't be given to the jury during deliberations. Are you sure it's 20? It's for exhibit.
It is. It's a,
Defense 20.
no, it's defense 20.
It's defense.
Well,
proposed
it's got
20.
numbered.
Oh. It's going to be 200 and something. Okay. Yeah. Give me a second. I'll figure that out. And should we put it on the CD?
Anywhere from 256 to 272. You'll have to figure out which one it is. But we can clarify that. Might have to look at the actual exhibit.
Yeah. Ladies and gentlemen, we're going to ask that you take all of your belongings with you for lunch.
Anything else?
Basically, grab your shit and go.
Remind me
Okay,
to,
then.
Clarify which one it is when we get back from lunch, but your staff can look at or your team can look at the exhibits.
All right. Well, that's all of that for now. Yeah, and the jury instructions, from what I've heard with Karen Reed, made it so it was a hung jury by how it was worded, and apparently it was confusing, and apparently there wasn't even a not guilty checkbox. So, you know, now we're in a retrial because according to the jury, they found the instructions to be very confusing. So even though jury instructions super boring to sit through, they are really what it all comes down to, you know? So what do you guys think? What would your verdict be? For me, I would say guilty. I can't buy into the self-defense claim because clearly he was shot a second time while already on the floor. So that already negates that for me. And then, of course, the conspiracy is kind of obvious. I mean, he was clearly lured to the house by Lori in hopes of seeing JJ. So I think they're going to find her guilty, but you never know. That's the thing with juries, right? Like even lawyers will say, like, you cannot predict how a jury is going to go at all. So I'm going to predict it do the opposite of what they
So we're
say.
gonna do it anyway.
We're gonna do it anyway. It's fun because we're not lawyers. We can do what we want. I can't. How do you think her closing is gonna go? Were you, ladies and gentlemen gentlemen and lady of the jury, were any of you there witnessing me conspiring for the murder of my husband?
Mm-hmm.
I just looked it up in the dictionary. Lori Daybell Vallow, guilty. Lady in Gray agrees with all my points. Thank you, Lady in Gray. You know, and even, let's say, even if he did have, I don't even believe that they had a reasonable, they did say something in the jury instructions about aggravating the perpetrator. You know, she took his phone and wouldn't let him see his kid. Like, they kind of instigated, because we've heard nothing about him being an angry, confrontational kind of guy. You know, I don't believe Alex was threatened for 1 second, even if he was holding a bat. So I don't buy it. It was a family tragedy. It was. It is. I mean, oh my gosh, so many dead people everywhere. So sad. And it's like she doesn't. She makes me so angry.
It doesn't like faze her at all that all these people, including her 2 children, are just gone.
Horrifically. Ugh. The instructions said there didn't have to be a meeting within minutes. Right. Exactly. Oh, you're late. That's okay, Kelly. Welcome. They just read jury instructions. Closing arguments aren't going to start for about another hour. Closing arguments, that's what I said, right? Yes. Those will start in about 1 hour, and then it goes to the jury. So don't worry. Just missed the jury instructions. Well, you can imagine being married to Lori. I am surprised he wasn't confrontational. I mean, the patience of a saint, that guy. And when you guys watch, like if you go and watch his body cam of when he was trying to get Lori help, like he's just the nicest guy. And we know she's being like a real big bitch face to him the whole time. Oh, yes. I started this comment because Buffy, what are you even saying? Are you telling us that every morning they literally start with "Hear ye, hear ye"?
Please, I hope so.
I've
Please
never heard that ever in a trial. Is that real life? Oh man, that's gonna be fun. Yes, Angie says yes. Buffy says that's how they start the trial. Kelly says yes.
Hear ye.
Every day. Okay.
Wow.
I've never heard that in a trial that we've watched before. I didn't even know we did that. I didn't know that was a real thing.
With a Boston accent.
Oh, wow. We're going to have so much fun. Are they like, hear ye, the Honorable Judge Auntie Bev?
Yeah, that's what I'm going to like.
Is that what they do? Like in the
all
movie?
rise for the judge, blah, 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 blah. And then hear ye, like, what? She said, no, it's way better.
No, it's way better. Oh, wow. Okay.
Okay.
All right.
Okay.
Well, that's
3 hearings.
Specifically 3. Hear ye, hear ye, hear ye. Oh my gosh, I can't even.
So do they, at what point? I guess we're just going to have to
start the day.
But I mean,
every
like,
day.
you know, hear ye, all rise, or like, you know, all rise, blah, 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 and then hear ye's.
It's very dramatic.
This is important.
Is what I know. This is crazy.
Okay, so it is when the judge comes in.
Okay. As they rise for the judge. Well,
so
that's
does it take place of all rise?
I think they're probably like, hear ye, hear ye, hear ye, all rise for the Honorable Judge Auntie Bev.
Auntie Bev. Okay.
Apparently
Wow,
that's what the
this
cool
is
kids call her.
great.
So, and she's like, no, that's not what they do. Amy says it's part
Okay,
of it.
so
And
it's
then
part of it.
we don't know.
I hope not 80s.
That's, oh my God.
Can you imagine?
Right. Oh, there is another part, Buffy says. Okay. Well, okay. I guess they'll make sure we're wide awake in the morning. I have never.
Hear ye, hear ye, hear ye. Draw near and be heard.
I mean, it is 2025, right?
Okay.
I mean, I imagine
that's
Boston is probably like one of the oldest court judicial systems in America, I would think.
I suppose so.
Yeah. Wait, is it because they're called a commonwealth? Because I don't understand why certain states are commonwealths and others aren't. I don't even know what that means,
I
to
don't
be honest with you.
either.
I don't understand that. But it seems to be like the colonies like to call themselves the Commonwealth. Shut up. It's very old timey. Do they just have regular robes? Does she wear like a frilly lace thing?
I gotta look her up now. It's Boston Commonwealth.
Bougie.
All right, let's
Boy.
see.
All right. I'm looking forward to it. That's crazy. It's gonna crack me up every morning. I don't even know if I'm gonna be able to sleep tonight, you guys. I'm kind of nervous about tomorrow, but it also feels like Christmas, I guess, because I don't know what to expect. So we'll see. I'll probably have just stayed up all night and be like here at 8:30 in the morning, just like all hopped up on coffee, like I'm ready. Oh, Buffy says, "All rise, hear ye, hear ye, hear ye. All persons having anything to do before the honorable, the justices of the court draw near, give your attention, and you shall be heard. God save the Commonwealth." Shut up.
What?
Are you serious? Okay. That's fun. Okay. And you're in there so special. I mean, gosh, yeah, that is pomp and circumstance right there. Just a regular. Oh, I'm sorry, I didn't finish it. I saw there was an add-on. God save the Commonwealth of Massachusetts. Court is open. You may be seated. Okay.
Google says there is absolutely no difference between state and commonwealth.
Oh,
So it's just which
those damn
which one they
Yankees
want to say.
wanting to feel special. That's hilarious. Oh my gosh, I can't wait for that to happen. Do they do it too? Like when they come back from lunch? Mama gets an Oscar. Well, thank you, Kelly. I'm sure it'll get better as we go along because I won't be able to help myself. Oh my gosh, that's amazing. You know, the old colonies who think they're important because they are OG. Yeah. It is there. I mean, I guess there's some, history big to do. Sometimes we don't hear it because of the stream. Okay, well, listen, I will write that down. And if we fail to hear it, I will deliver it every morning for you. How's that? Are we all happy about that? So make sure you subscribe to True Crime in One Time, where you will catch us tomorrow morning at 8:30 Eastern to cover Karen Reed. And I'll get better at my introduction. Apparently. Wasn't the Mayflower in Massachusetts? Plymouth? Yes. We need a soundbite clip, or yes, Llama will just do it.
I think I saw that lady in gray.
Just put Auntie Bev in the spot where the judge team goes. Kentucky's a Commonwealth too. Okay. That's interesting. I know, Kelly. 5:30 your time. I am not a morning person either, girl. Me either. But you could probably watch the morning maybe a little quicker and be caught up by their lunch break. Because I think they said lunch is gonna be 1 my time, which is 10 your time, I think. I feel bad for you, girl. Oh, 6:30 for Angie. You might have to 2 times. Oh my God. Are you going to watch with us, Billy? Because I don't even want to know what I sound like. What do you think we sound like at 2 times the speed? Don't tell
Quick.
me. Don't anyone tell me I don't want to know. I'll never do this again. Kentucky, Virginia, Pennsylvania, and Massachusetts are all
Lady in
common.
Gray. That's funny.
Oh, and then you just put in there too. Hear ye, I shall suffer. Yes. Just make that your guys' ringtone. Very, very fast. I cannot listen to stuff speed up. I know Annie listens to stuff super. I can't do it at all. The max I can go is like 1.25, and that's one fast. Right.
I wish we had like the speed up button in real life, because some of these people in the South are just taking their time. They are leisurely talking.
What was it? It was the Richard Allen, when we were watching the interrogation of Richard Allen. Who, boy, they talk slow in Indiana. Well, a lot of things are slow in Indiana, but your ears might get blasted when police sirens go off constantly. So Elbow Feet was telling me. Now, who knows? Because apparently he watched the first trial with DUI guy. But apparently a bunch of people noticed that, and this is a conspiracy, I'm not promoting it, I'm just putting it out there. You guys will know more than I do. So I'm like, this sounds crazy, but also considering everything else, maybe it's not crazy. But anyway, apparently a lot of people believe that if you're watching and a cop is on the stand, when they get close to saying things that they probably shouldn't, all of us, because there's a police station right there, that all of a sudden the police sirens turn on. Like every time a cop goes to maybe saying things that they shouldn't say. Apparently that's a conspiracy going around. I'm just spreading rumors. See. I mean, I don't know. I was like, I mean, it's Boston. I would imagine that the sirens are always going off, but I don't know. So, the courthouse is probably 150 years old, and Aunt Bev will make sure to mention that more than once. Oh, does she give a history? I mean, I'm a nerd. I like architecture history, so, and it makes it hard for tech issues and AC. Oh, did they not have AC? Oh my gosh. Conspiracy corner. Oh, that could be like a segment for Couch Court. Conspiracy corner, Couch Court. It did that during the hearings too. Oh, so he's not spouting off, like, because he gets into it. That threatens to turn off the air if they don't speak loud enough. Jeez.
What?
Do they have
How
microphones?
old is she?
Oh, she looks like be like in at least her 60s.
Oh.
I hear she's a real piece of work. Like Judge Gall, piece of work from Delphi. Even though none of us saw Gall on camera, but that kind of level of fool. Nobody was turning. It was a coincidence. Nobody was testifying. Oh, okay. It's weird. Was that a horn?
Oh, she looks delightful.
I watched Larry. That is a bit dramatic for me. A little bit. But yeah, I mean, the station's right there. As first, Judge. Oh wait, hold on. Where's the hear ye? Hear ye, hear ye, hear ye. Judge Beverly Canone. Canoni. How did? Uh oh. I think it's Canoni.
Somebody's first in her bench, Slayer of the
Common Sense, Defender of Commonwealth, and the Iron Gavel of Norfolk. I love it. We're gonna have so much fun, you guys. I'm really excited. It's just gonna be us hanging out. I love it.
Canoni.
Oh, so I was right. Canoni.
Canoni.
like cannoli, but without the L.
Cannoni.
Buffy does an excellent Bev impression. Well, somebody's going to have to come on the stream with us and do it.
Cannoni. Okay.
Cannoni.
Judge Cannoni. Okay.
Oh, I'm glad we worked that out on this stream.
I know.
Cannoni. It does sound like cannoli.
Judge Cannoli.
Oh, she'd probably hate us for that.
I was gonna say we better stop her. She's gonna turn our air off.
Right? Oh no. She put us in contempt. Cannoni. Okay. Noted.
Judge Cannoli.
Oh, excuse me. Cannoli. Oh, we're gonna have so much fun, you guys. I'm pretty excited about it. I don't know how we're gonna entertain y'all for 8 hours, but we'll see. Fancy Bev. What? Okay, so I realize a lot of people say auntie or auntie, but here most people say auntie. Not very many people say auntie
here.
Mm.
I said it goes both ways here.
Oh, okay. Oh yeah, maybe we should. After today, Buffy, we're gonna need a call for you so you can tell us how to properly pronounce everyone's name. What is that? Alessi? That seems reasonable. So nobody. We all know Terry can't do impersonations. That's true. Or pronouncing last names correctly. But don't worry, girl, me too. I will sometimes go and find an interview that somebody's done, like a news thing, I'd be like, oh, is that how you say it? You say aunt here? Yeah. I think it's an Appalachia thing. So.
I was going to say, we say aunt and aunt. It just depends.
It's the way she pronounces her ace. She says half off.
Her A's. I think that was my.
Half. She says half. Oh, I get it now. I get it. Oh,
I think it was like a speech to text thing or something.
Well, we're definitely probably going to need subtitles then, for sure. Buffy can do the right Boston accent. Yeah. Brennan always. So it is Alessi. Okay. A's. She said ace. Okay. I do the same and then forget.
I had a boss who there was only one name she couldn't get right, and it didn't. I mean, she heard it all day, every day, and it was she just could never get it right. Even the lady came up and she's like, "It's Elisha, like elated."
Oh gosh!
And every single time she was Alicia or something crazy.
Mm-hmm. When I read books, I don't know. Sometimes I won't read their names right, but then I've read it so many times. It's like what I think it is. That when you learn like how it is, you're like, it's so hard to like rewire your brain,
Mm-hmm.
Sidebar, shock and horror. Shock and horror. Horror.
Terry.
Kind of like war stars. Oh my gosh, horror. Oh my gosh, they're gonna be so dramatic.
Sidebar. Oh no.
Sidebar. Because they don't say R's. I think they say them as H's.
When we were in Boston recently, it was not as thick. The accent was not as thick as we thought it was going to be, and it was probably. I mean, I'm sure we could have like found, where it was thicker, but I expected more. I was so excited to hear the thick Boston accent, and we were like, oh no, nothing.
I wonder if because it's such a big city, there's a lot of transplants there. I bet
I will tell you
neighborhoods of Boston, you'd probably hear it everywhere. I bet.
There's
Tomorrow,
some. Oh yeah,
I'm crazy. But they do add it in other places. Oh, that's fun. Well, I mean, they're dramatic.
Boston.
So, oh my gosh, I can't believe they do this announcement every morning. Amazing. Almost all male cop witnesses look the same. Oh, great. I bet. Do they all look like that lead one? I know the lead detective's name is Proctor. I know that. So they all look like that guy? Do the cops all have thick Boston accents at the very least? They're all bald. But it was Halloween. Oh, goodness. All bald. Chat is saying they're all bald. Well,
Yeah.
I mean, like, I don't know much about the case. I do have some, like, questions, like, why would you back up and kill your boyfriend and leave him dead in front of a cop party house? Like, that seems really illogical. Like, that seems like the worst idea ever. I'm sure we'll learn more details of that, but, like, I was just like, that seems real dumb. Real dumb, because people would be walking up into that. I haven't seen the photos of the house and stuff, so maybe it's further away. I don't know. There are no trial daddies. Ugh. Well, that's disappointing. Not even the lawyers. Buffy was telling me last night about, I haven't watched it yet because I was up late and I wanted to watch Agents of S.H.I.E.L.D. instead. But apparently, like, there's a Karen Reed documentary on HBO that she said that the defense had reached out to this production company to do this documentary. So it's kind of like this staircase with Michael Peterson, like how it followed his defense team through the whole court process, like their, strategy meetings, like days after court, all of that. And all that was filmed during the first trial. And well, here we are for a second one. And apparently Karen said some things in there that the prosecution plans on using in the trial. So I don't know what that means, but that's not great. But it does sound interesting. I like the fact that it's done from a perspective, you don't get to see that often. You don't get to see the war planning and strategy planning and all of that. So I'll probably watch that here soon-ish, maybe next weekend. And Alyssa, it's brain food attractive. What's that? What does that mean?
I have to look at this. Is it a person?
Alessi, yeah, that's one of the lawyers. She has like 4 or 5 lawyers or something now. Yeah. Jackson looked better before I got glasses. And his name's Alan Jackson, right? Like the country singer? Okay. Oh, Kelly says Alan Jackson is definitely handsome. I had the Canton PD in mind. Yeah, I know something. Alessia smart. Oop. Alessi has all of my adorations. Oh, yes, the more Alessi talks, the hotter he gets. Oh, I don't know why I just kind of assumed it was a female.
I did too. I'm over here looking.
Definitely Mr. Cannon Arica. I don't know what that means. Is somebody's name Cannon?
Why can't I find a picture of him?
Okay, all right. So chat is hot for Alessi. People are digging Alessi. Now, is this
what?
Alessi just joined for this trial? Or was he in the last one as well?
Does he have like curling hair and maybe a balding head? Because I don't know. I don't know if we're talking about the same person, y'all.
Well, wonder if I'm going to be missing what, if anything. Because I do. Oh gosh, isn't that the worst when prosecute? Oh my gosh. What's her name? Debbie Heard. Oh, it was always what if anything. And then the same lady, because we called her whatever 2.0 from Depp Heard. She was always what if anything.
Elaine.
Elaine, yes, thank you. Yes.
Mm-hmm.
Oh, Oh, he made a cannon for the experiment? A whole cannon? Are there cannons involved?
Y'all, he is
Why not?
not cute. I mean, everybody has their own opinion. He just not
Maybe he doesn't photograph well. I don't think I photograph well. So maybe there's
not. Amos heard my struggling and sent me pictures.
Oh, a new attorney who just joined the team is a former juror from I heard that one of the alternate jurors, who is a lawyer, is now on Karen's defense team. Can you believe? And did you know? They also were telling me last night that the oh my gosh, the head juror. Why can't I think of what the head juror is called right now? Jeez. Oh, jury foreman was a cop. You fall in love with Elisa's brain. I mean,
okay, I can
that's
see.
what I find.
Brains are attractive, top tier.
Oh yeah, I find brains to be way more attractive. I can't talk to idiots. And being funny; those are my two most important.
Well, usually, being funny comes with being brainy. Like you know.
That's true. That's true.
At least the kind of humor that is actually funny and not just like slapstick.
Yeah. Just joined the team. Dr. Whoop is from ARCA. Joined for this trial. Ooh, we have to listen to Alyssa talk. Boston accent. I mean, I am a sucker for accents. I don't know if there's ever been a Boston accent where I'm like, yes. I don't know. But maybe. He has a vocabulary.
I had a Boston boss one time.
Oh, gosh. Oh, I'm getting hot and bothered over here. Smarts do get me going. So.
Oh, chat.
I love that. Right? Look at them already thirsty in the.
I know. Goodness. Now I'll go look at my. Hold
on. Brennan sounds like and looks like a weasel. Oh my gosh. Buffy a couple of days ago when she found out we were doing this, she said that Brennan looked like in The Incredibles, his insurance boss. Mr. Incredible's like insurance boss. Apparently.
Oh no. Oh no.
Oh my gosh, I know, right? I love this. Alyssa's from New York. Okay. Does he have like a Brooklyn accent? I do like those. Keep your dictionary close. Okay. Do I even have a dictionary? Yes, I do. I was like, do I even have one? I do. And he came prepared with a binder with tabs and all he prepared the night before for here. Oh, that's sexy.
That's hot.
Oh, do I love binders. Oh my goodness. Hank Brennan is the former defense attorney for Whitey Bulger, a mob boss. So the prosecutor is the defense attorney for a mobster. Okay. We are literally talking about this trial like it's a new season of the next big series. Well, I mean, it seems very, very fascinating. Will love Liza Little. Is that the new alternate juror, the lady lawyer? Marky Mark has a Boston accent. Oh yeah, that's true. But I don't really like the way he talks. I mean, he's very good looking, but I don't know.
What was he in?
Well, first, let's do the history of Marky Mark, shall we? So he was like a rapper in the 90s, but like a white rapper in the early 90s. And then he's been in a bunch of movies and everything. He was in The Departed. Maybe I'm trying to think of like newer-ish movies. He's been in like, he's in a lot of things you would know. I mean, he also now owns a car dealership here in Ohio and Whataburger, I think it is, or something. I don't know.
Is that what
Oh
he
my
goes by,
goodness.
Marky Mark?
No, that was part of his rap group, Marky
Oh,
Mark and the Funky Bunch. And he was a Calvin Klein model. And oh my, those underwear pictures. Oh my, the 90s were
what's
what?
it? Oh,
Mhm.
Mark Wahlberg.
Oh, Liza's Jackson's partner. Okay, so she was there for both trials. It is a new big series. It's Couch Court with Llama and friends. You know, because one of the things I want to do before I go looking at the other comments. So when I first started watching trials on YouTube, when did I mean, I've watched trials in the past. I watched Menendez, I watched Casey Anthony, those, you know, back in the day. But before I started going on YouTube for them, the first trial I watched was the Kyle Rittenhouse trial, which is a fantastic trial. I know a lot of people still have opinions about it, and I feel like they didn't watch the trial, but it is a very fascinating trial for numerous reasons. We won't get into it. But so that's kind of when LawTube first started happening, where all the lawyers would get together and watch the case together. And it was really cool because there was like a panel of them throughout the whole trial, right? So they just all had different opinions and perspectives. And it was really, really cool to see so many different people's brains working. And then they would have, you know, discussions. Like they all had different opinions, but they were able to have a civilized, reasonable, you know, discussion. Now, granted, we're not lawyers. We're all just, you know, average like you. But, you know, I know I would like to have, I appreciate different perspectives, especially in something like this, because these things are in black and white, you know, and I think some people have unpopular opinions. I have unpopular opinions about Murdaugh, about Zachariah Anderson. I both think that they shouldn't have been found guilty, you know.
Mhm.
But so then after that, they all disbanded the panel. Says no, they did do panels for Debt Be Heard, if I do remember right. They were smaller ones, but then they all just kind of did their own. And like it's great to have like one person to like be on here and listen to, but like there's so many things I won't catch or think of. So we're going to have other people on with their opinions too. And I'm really excited about that because I feel like we don't have that anymore. And it was like one of my favorite things. Okay. Enough of that soapbox. I don't even know where we are in comments over here. Oh, we're talking about Marky Mark Ryan. Please do not start on Mark. No, right? Don't even get me started. But yeah, so that's what I'm hoping we can do with it. I think it'll be a good time. And I think Karen's a great trial to start that with. So you didn't watch Zachariah Anderson? That's a Wisconsin one. That was a pretty interesting trial. I don't know. They just didn't have enough to convince. I would have hung the jury. I'll just put it that way.
Mm.
So I don't think their case and the prosecutor. Oh gosh. Oh, there's a lot going on with that trial. The prosecutor almost became a witness in the trial. It's crazy. It has some very spicy moments, by the way. Now, do I think
liked
he
the
stalked
judge
his
for
ex?
that one.
Yes. It's the same judge from Kyle Rittenhouse.
Oh, I do.
Mhm.
Okay. I thought
Yeah.
I just liked that he was kind of no nonsense. I mean, you know, he was an
Yeah.
older judge.
Yeah, he was the same
But-
one for Rittenhouse. Yeah, Zachariah Anderson was a wild trial. Amos the Greats too.
Same,
Yeah.
Amy.
I think I called into Recovery Addict on that one, being like, no, they just didn't have enough for me. So I would have found him for the stalking because he definitely was a stalking sex. But I don't think he actually had anything to do with that guy. Doesn't make a lot of sense to me. Schroeder, a lot of people like him. I don't. Unpopular opinion. He can be very slow and boring sometimes.
Yes, there were definitely
thought he was-
times where I 2 times
Yeah.
speeded him.
I will say that I thought he livened up a little bit with Zachariah compared to Rittenhouse, but oh boy, can he be slow and go on. But
I think my first trial was Debt v.
Me too.
Heard or her. Yeah. I think that was the first one I got that got me into it.
Because I'm trying to think. It was like I did Rittenhouse, then Chandler Halderson was that January. And I can't remember in between there. But then in the fall, I watched Parkland, which is a very good trial to watch. The Parkland mass shooting trial. It is devastating. You will cry so much. But, you know, we haven't really ever been able to see a trial like that before. So it's quite fascinating. I was very infuriated that he didn't get the death penalty. I call a bunch of bullshit on that, but, you know, whatever. But I watched, it was the Parkland shooting trial was going on the same time that Darrell Brooks was going on, the same time that George Wagner from the Pike County Massacre trial was going on. And they went on for like 3 months. It was the longest 3 months of my life trying to catch up on all of those. And then there was the antifreeze guy also from Wisconsin.
Oh, yeah.
What was his name? That was my first
I don't
show.
remember, but that was crazy.
Yeah, him. And then it was started with Murdaugh, and then Depp Heard, and so on and so on and so on. So
was Murdoch was after Depp, right?
yes, it was. I got my years mixed up. Yes.
Okay, I was like, I swear, I thought my first one was Depp, and then
it'd be Depp,
I ended
and
up
then
going
the
back and
following
watching.
January was Murdaugh. You're right. Yeah.
But then, I mean, I went back and watched because I totally missed Brooks, and I mean, you can't miss that trial. You have to watch that trial. So I went back and watched that one.
It's a must see for everyone.
I think my first trial with RA was Murdaugh.
Murdaugh, probably.
Yeah.
Right, that makes sense because we became friends like right after Murdaugh, so that makes sense. That was Anderson was the one where the judge was somehow streaming RA. And he came live on the courtroom as we were watching, and we're all just like, what is happening here? It was so crazy to watch. That was a lot.
Yeah, that was crazy.
That's a lot. Oh yeah, and Travis Rudolph. I forgot about that one. The football player.
Me too.
Yeah, that was a crazy one. You know, like some people think watching trials is boring, but like
some of those witnesses were saucy.
Mm-hmm. Yeah. I think Halderson and Brooks are the best opening statements I've heard. Yes.
That's where knowledgeable child came from.
Travis Rudolph. Yeah, that's right.
So the Rudolph one, knowledgeable child.
Yeah, I think the Halderson prosecution opening statement is the best opening statement I ever heard. It's such a banger. It's so good. And that guy had it memorized. Like, for that kind of, like, he did a phenomenal job.
Is the Rudolph one where I didn't come here to read came from too? I think so.
Was that a trial thing or just a common?
I think that there were, if not, there was some sort of something similar to that.
Maybe. I don't know.
I don't look at it.
And butt implants. Oh, there were. That's when we all learned about Brazilian butt implants. That's true. And a whole husband. Oh, it's train time. Choo choo. Oh, we should think of something fun to do every time we hear a train, which is quite a few times. People are saying yes about that. Annie.
Oh, okay, cool.
That it was the witness that said I didn't come here to read. Okay. It was the knowledgeable child that said that. She was.
Okay.
Yes. Or he did not come to read. Oh, either way, what a wild trial that ended up. Those people are crazy. I hear that the witnesses in Karen Reed are like, you think that they were in high school. Like they all suffer from like Arrested Development, apparently. Also act and think that they're in high school.
Is it like the police wives?
Mm-hmm. Yeah. And the cops, apparently. So we'll see.
I respect police. I'm a cop's daughter. I do. I respect them. But There's definitely a type sometimes.
Yeah,
There are multiple. There's like 3 types.
I was going to say, I don't know how much respect you're going to want to give to some of these if what the people have told me are true. So they're not making anybody look great, is all I'm saying. As Buffy said, just wait. Just wait. They all think they're above the law or the law.
Ugh. That's one of the types.
Yeah. Yeah. It seems like it. I gotta go get a soda. I am so thirsty. I'll be right back. Entertain the masses, Annie.
Salty. Oh no. Oh no. That is really up close and personal, y'all. Let's see what you say. The bad ones do not outnumber the good. That's true. The bad ones don't outnumber the good one. My dad was a good one, but I'm biased, so. True. In this trial, they do. Buffy, yeah. Yeah, from what I've heard, I'm not going to have anything nice to say about the officers in this trial. We don't do corrupt police. Oh, very cliquish. Yeah. Buffy, are you going to come on to Couch Court during the Karen Reed trial? You should. Ooh, we're way up here in comments. Good. I don't want to watch the first trial until after the second trial because I don't want to have. I'm assuming they're going to do stuff a little differently this time. Maybe some extra stuff will be admitted. I don't know if stuff will be left out, and I don't want extra information yet. So I'll watch it probably. I'll go back and watch it after this one's done. Ooh. Interesting. How so? Are they not? Are they just different tactics or different information allowed?
I'm back. Look at my cute coffee mug. I think Amy bought this for me for Christmas. I think it was on my birthday. I don't remember. But it's a Harry Potter one that appears and disappears depending how hot your coffee is. It's the Marauders map. Hold on, let me do it. It says Mischief
Buffy,
Managed.
that's so exciting. Kelly P says we should watch the first trial after watching this one. Buffy says this one's they're still getting new evidence for the Karen Reed
crazy.
Trial. Yeah.
How do you not
it's crazy
have all the evidence from the first one? Like, how is that possible?
Okay.
Girl, I just hear it's going to be a lot of us eye rolling and sighing and probably fist pounding. That's what I've heard. So,
Terry, hold on. She's seen Harry Potter, right?
Oh my gosh, Annie, we can't even get into it. Don't even get me started. Okay, I'm working on. Don't even get me started on Terry and Harry Potter. Everybody knows. Don't do it. Oh.
What about what about like Lord of the Rings?
Which is way more boring.
I could let Star Wars go, you know? But Harry Potter?
She said she's willing to watch a Star Wars movie instead. What? And I was like, okay.
That's fair.
Okay. So we're supposed to watch
I can't
New Hope, I guess.
I haven't seen stuff, but
I would pick Harry Potter over Star Wars any day, but that's just me. Mm-hmm. I'll break her down. I break everybody down. It'll happen one of these days. Because
Harry
the
Potter
prosecutor did-
is better. Sorry.
Oh, then Star Wars? I agree. I agree. Now
Yeah,
I'm really
really.
dead. Lord of the Rings too. Oh, that's fair though, because it's like Doctor Who. Oh, there's no
Don't
way
mess
Carrie's
with
watched Doctor Who.
us.
Yeah, don't
Don't
even.
mess with us on Doctor Who. Don't go there.
Harry Potter for sure. And yes, Llama does go rants about Harry Potter with Harry.
Ugh.
I love it. It's fun. It's fun. Not everybody loves the same things, and that's totally fine. You know?
Bells,
And
what are
I'm
you
a
talking
huge
about?
entertainment nerd. Like I watch too much TV and movies and read too many books. So yeah, that's right. Bells had not read the books or seen the movies until we did that marathon last year in the Courtyard. Oh yeah, by the way, that's our channel there. You can join our Discord. That's where we all hang out. Oh, we have something that says the Courtyard somewhere.
Oh my gracious. Oh,
There's that. Oh gosh.
oh, we both clicked it.
Okay. But yes, we're in the Courtyard. That's where we'll be hanging out after hours. There's lots of people there. We discuss true crime and also watch just fun things. Not everything's true crime all the time. But
Like Natalie Grace.
right? Oh, that was
true.
wild.
Crazy.
That was wild. But yeah, that's right. Belle's watched them all and she loves Snape. And then she enjoyed them.
What part was she?
This always she goes and watch it. Spends how many hours are we at that point? Like 9 hours. And she goes and cleans the litter box during always for that whole scene. And we're like, she gets back and we're like, girl, girl, you gotta be here to be here for that. Yeah. Yeah. I know. And we're like, but that's why she's a Slytherin. So I told it was very important. It was like the utmost of importance. Completely redeems a character
Completely.
in ways you didn't see coming. No,
Ugh,
I cried so hard when I read that. Anyway, we won't sit here and talk about Harry Potter the whole time,
that's
even
fine.
though I
That's
could.
fine.
Could do a
Okay,
whole
I'll be
show
right back.
about all the shows that I loved. So this coffee's a little hot. Ooh, boy, that is, I am big on the screen now. That's flattering. Oh, yeah. So I got one of like these green screen things that'll like attach to my chair. And I was thinking, we could decide each day like what my background would be. I think that'd be fun. We'll change it up to fit the theme every day. Or people can send me things to make as my backdrop. So there's that. Sorry. Oh, it was just an email. Hold on, let me get rid of that because now it's coming there. Okay. Where were we? 34 Fairview. What does that mean? What is that about? I don't know. Oh, is that the address for Karen Reed? Or for the house party? As your backdrop? Is that what that is? Ah, clever. Clever. Okay. It's very clever. Let's see. The address of the incident. Okay. And solo cups. You know, Angie had a brilliant idea that I should use drink only out of solo cups. I haven't gotten any, but I'm going to make a feet stop in the store, you know, maybe tomorrow. Because I was like, that is pretty clever. Ugh. I just can't believe they collected evidence now. I don't know. I shouldn't say anything. I've only heard what people have said. And we'll see. I'll save my what the F for all that. I did hear that they use the see you next Tuesday word a lot in this trial. So that's fun for court. Oh, hold on. I gotta let my doggies out. I don't have music, but 2 seconds. Okay, ladies. Okay, sorry. Those ladies had to go outside. Your favorite co-hosts, Zoe and Gita. Gonna go potty. You have pink solo cups? Of course you do. Of course you do. I love that. Bev made them say that. I love how you worded that. That's hilarious. Like, oh boy. Oh boy. Could you imagine having to say that in court? Oof. Oh, it's just during Proctor's testimony? Well, is it a lot? Or is it just like one time? Oh, he tried not to read it, but Bev said he had to because it was his own words, right? You're like, maybe you shouldn't say things you wouldn't, that's what they say about your sending messages to people. All right. You would only say things that you would be comfortable with saying in court on the witness stand under oath. Otherwise, you probably shouldn't send it, guys. Probably shouldn't send it. Well, and that's right. Unless you're Amy, who says it when we're live with Lori Vallow. Oh, goodness. Oh, my goodness. So maybe in once or twice, maybe in closing. Is this the new cam? Oh, if it is the new cam. Yes.
Doesn't she look good?
I like it. It doesn't have a light, so, but now the light seems to be a little bit better. I don't know what to do about all that, but you have purple and turquoise red solo cups. Okay, babe, you're gonna have to go buy me red solo cups and pretzels. And what other kind of snacks do we want Elbow Feet to go buy after work today?
I have red solo cups, so I'm ready there.
You're ready there? Oh, I'm sure these women in Canton are used to, well, probably. Oh, yikes. I mean, I don't have a problem with the word. Most of the world doesn't have a problem with that word, but I would be very embarrassed to have to say that in court, let alone being a police officer having to say that in court. Ooh, the secondhand embarrassment is real. Yikes.
Skittles.
Oh, yeah. Bells was saying, Olivia, if you're listening, Bells was saying she got these freezer dried Skittles.
They're good.
You've had them?
Yeah.
What? I don't understand it.
I don't either, but they're good. So whenever we do events for our business, there's always some around. Like people are always doing stuff like that. So I always get the
no, you don't have to go today, babe.
Skittles.
You can go tomorrow. It's fine.
Like, for real?
Like, are you joking?
Do you really want snacks?
I mean, I always want snacks, but
they do all sorts of freeze-dried candy, though. They'll do like freeze-dried Starburst, freeze-dried Skittles, Nerds, like Nerd Ropes, too. Those aren't... I don't think they're really... Like, they're good, but I wouldn't go out of my way to get them. I think they're better the normal way.
Okay.
Yeah.
Belle says they are good. She loves them.
They are good.
So, are they just with the regular candy?
Yeah, so I mean, they do like all variations. They'll do sour Skittles, regular Skittles.
I love sour Skittles.
They good though.
The Skittles are sour. Nice. That's what I'm talking about. I'm really big into the Lifesaver gummies right now. I love my gummy things, my gummy bears. Oh, babe, you're going to have to get more gummy bears because I'm almost done with gummy bears.
I ate so much strawberry and cheese and apples.
I had to stop eating gummy bears for a couple of days because I was like, I think I might have eaten too many gummy bears. They're so good. They're actually a sugar overload. Oh my. The drinks are White Claw, vodka, and Crystal Light. What the F? Okay. Michelob Light or Ultra. Probably Michelob Ultra. That totally checks out with these people, probably. We found out all their drinks multiple times. Okay.
I would take White Claw over everything else they mentioned, but I'm a red wine girl, so.
I mean, vodka's not bad in anything. Nope. Man down.
Ooh.
Man down. We had a gummy bear down, everybody. It's fine.
I
Saved his
can't
life.
wait
Now I'm going to eat him.
for an espresso martini and a White Russian after this baby. Like the two things. I don't know why. I just want them so bad.
You get him, girl. You get him.
Mm-hmm. I'm going to drink all the espresso martinis.
And it was snowing. And Jameson. Of course, that makes sense. Whiskey and ginger. No. It may have been snowing, and there are like 5 high top tables. That's oddly specific.
What?
They were at like a bar before they went to
I
the
know
cop
it
party
was
house.
like the something bar and grill. I have it written somewhere.
On it. Didn't this sound like during a weekday? No, 2 bars.
Ooh. Waterfall bar and grill. Buffy knows what she's talking about.
Oh, waterfall, they say, yeah. And we still don't know what the band was playing. That's the most important part. Waterfall and CF McCarthy's and
At this point,
Creekside or
Buffy could tell me that Karen drop kicked the judge in the face, and I'd believe her. Be like, yeah, that totally, absolutely, 100%. Buffy said so.
Legit. Buffy said so. It's legit. I'm fine. My peep teenies were an espresso type martini. Oh my.
Ooh.
Oh my. Why are the high tops relevant? Buffy says, oh my God, that's funny. I mean, it's true. Ow. Though people say that about me too. Like, oh yeah, if Loma tells me something, then it must be right?
Oh,
like,
yeah.
But that's not true because you guys, there's a lot of times I'm wrong. Don't tell elbow feet. But there are times that I am wrong.
This is recorded now.
I know, right? This is live on the internet. So one year, I don't know what it was, but I had convinced, I had the wrong, so it was like a Friday. Okay, this is in June. It was a Friday. And I thought Father's Day was like Sunday. And I had like 4 or 5 different conversations with people about it. And they were like, oh, I didn't realize Father's Day was this Sunday. And I was like, yeah, isn't that crazy? Convinced 4 to 5 people that Father's Day was on Sunday, and it wasn't for like a whole nother week. They just went on and were like, oh yeah, that checks out. Tara said so.
Totally.
I was like, you can't believe everything I say. Because I think it was my bestie messaged me, and she on Sunday, she's like, it's not Father's Day. And I was like, well,
just so we're aware.
Sometimes I don't know.
Hi, Kitty.
High tops aren't relevant. That's the point. Oh, okay. But we're going to hear a lot about them. Okay. That's fun. They made snow and high tops relevant.
The Commonwealth.
Hear ye, hear ye, hear ye.
Hear
Three,
ye.
hear ye. Oh my goodness. I mean, why are they making a big deal about snow? Of course there's probably snow. They're in Massachusetts.
Lolly made it relevant.
Were they dancing on the tabletops? Narrator, it was in fact not relevant. Oh boy, look at that. We're past 4 o'clock. Of course, supposed to come back in like
Wow.
15 minutes. Look at us. We did a good job. Okay.
We did great.
Yeah. Oh, so it was, but he beat the horse. Oh, okay. So it was kind of like Lori with the bamboo shirt.
Uh-uh.
Oh, do we think Lori's going to bring up bamboo shirt to the jury?
Yes, absolutely. 100%. If not, I'll be disappointed in her, frankly.
Well, there was a blizzard, so all the cops and families went to bars and drove drunk. Wow.
Okay, so I heard that, that they were at the bar, blah, 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 and then they ended up at, I think it was the Albert's house, one of the cop families, anyway.
Mm-hmm.
And I was wondering if they Ubered or got a DD there, but I mean, did they literally drive there themselves? I guess we'll hear about it in the trial, but
yeah, I guess so.
What a good example. Okay, yes, the Alberts.
Yeah.
Wow.
Alberta. They were all driving drunk. That's cute. During a blizzard.
Wow.
What kind of blizzard? I mean,
way to think you're above the law.
Well, I mean,
Wow. Did they all get some sort of discipline for that? I mean, besides the one that was fired. Probably not.
Because I think they're charging Karen with driving drunk, which I don't really understand how they could have gotten to that.
Oh.
Okay. It was a Reese Cup blizzard. Those are so good. They do it regularly too, according to testimony. Okay. Fun.
Cool.
Super great. The snowy kind. The blizzard was like weak sauce, even for Texas. Okay. That's why I'm like, is it technically a blizzard, or is this just what a lot of people think is a blizzard? And it's not. It's just normal snow. But our southern friends know what it's like to be in a blizzard since they had their first one this year. So
we did not. They did.
Didn't Higgins misplace his gun? Jesus. Okay. His service weapon? Yikes.
Wow.
Annie, I think we're going to get so fired up.
I know. Ugh.
My brain already hurts a little bit. What?
What?
Yes. And at one time, Higgins left his gun in the other cop's personal car and badge. Oh, for fuck's sake. Well, there's going to be a lot of that. By the way, if you don't like curtsy wear, it's probably not the person for you.
Were they drinking with their what?
Sounds like it.
No. Well, I don't know. Maybe the rules are different there. Here, you can't take a sip of alcohol, not even a sip if you're carrying.
Yeah. Oh, that's here too. Yeah. They did map to figure out what her blood alcohol content would have been at the time of the murder based on her blood draw at the hospital after murder. How is that even still allowed as evidence? That wouldn't even track for a regular DUI case, I believe. A lawyer would get that knocked down to reckless op or something. That's why you don't blow. You just don't.
What?
No, one of them left their badge and weapon, not sure which one. Jeez, what a bunch of dum-dums. We watched a video to count how many drinks she had, but she got the vodka on the side and poured it in. Oh, so she thinks people are short in how much liquor they put in the drinks. That's why you do that. Oh, wow. The whole thing is crap. They had come from another cop's funeral in New York. Oh, so they're also like emotionally drinking because I'm sure these sound like emotionally stable individuals.
Wow.
The guys who did the audit of the Massachusetts State Police said the police drinking and driving in uniform in state cars was not a big deal. What? What? Okay. Okay. That's sure.
That would not fly here. Well, that would not fly in most counties here.
Yeah, that's crazy. Oh my
We've
goodness.
got one or two. It might be okay.
It'll drive us mad. It is. But that's one of the reasons why
wow.
Proctor got fired. That's the reason? Oh, so you know what else they have? So Proctor, he's the lead detective guy.
The one who did all the things?
Yeah,
Ugh.
I guess. I mean, whatever. He's like the lead guy. He got fired a couple months ago finally, but apparently he was also the lead detective in Brian Walsh, the guy who killed and cut up his wife in Massachusetts like a year ago. Who's going to trial. Anna Walsh. Anna Walsh was her name. Apparently he was the lead investigator for that case too. Yikes. Can't forget about the inverted video played in court and testifying as if it was a true recording. I have heard about that. That is effing nuts. There are 4 reasons, I think. Only 4? Wow. If you want to fire someone, you need valid reasons, especially with unions. I mean, I don't the context guy. I love that we're going to use that. I love that. Or the context.
Hi, baby. Come here.
Next 4. Don't forget the 4. Oh my God. I hate that chapping. I did. Why are you so noisy outside my house? Oh, elbow feet's home.
Oh, that's what's noisy.
I was like, why do I hear him?
Oh no. Oh no. I have created a problem.
What happened? Did they try to escape the yard maybe? Maybe. Oh goodness, you guys. I need sugar. I made a whole nother pot of coffee because I am a dragon over here today. Dragon, not dragon. I realized I said that kind of wrong. Because I got up at 8 because the internet guy was supposed to be here between 8 and 10. So Elbow woke me up at 8 in the morning and my eye stayed shut for 20 minutes. I was like, oh my God, how am I going to do this every day at 8:30 in the morning? But we'll get there.
I had cleaning to do because
how many times I have to tell you, buy cake, let them eat cake. Okay.
But do they have cake?
But do they have cake though? Oh wow. Okay. Let's see what's going on over here. Nothing. I keep saying it's supposed to rain. It doesn't rain. What? What are you talking about, Amy?
Yeah.
What is that in context?
I gotta scroll up because
there isn't.
It has breakfast food in it. Eggs.
Oh, cake has eggs. Never mind. There they are. Now see.
Oh.
We are so pretty, you guys. So pretty.
Amy, really funny, and I'm sorry that I didn't get it at first. That was me, not you.
Oh my goodness.
Oh, I'll be right back. I have brownies. That's what I'm missing.
Brownies.
I made
Ooh.
brownies. Well, I did not make brownies. Brent made brownies for me.
Oh, well, isn't that nice of him doing a little baking for you?
He's so I think it was for the baby, but I'm claiming it was for me.
It's both. Y'all are so pretty. Yeah, we're so pretty. Oh gosh, maybe not that big. Oh goodness. It's how they say it, Buffy. That's why I'm like, you're so pretty. It's like that. When I say, oh my God, you're so pretty, I really mean that. Y'all be slow. We are slow today. It's Monday. Give us a break. It's Monday. We're traveling in different time zones that are all over the place. Let's see, 12:45 their time, which is back in the courtroom, where is at the defense table, blah, 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 blah. All right, so they are back in court, but court is not on yet. So that's nice. How long you guys think Lori's closing argument's going to be? I say 15 minutes. Or she'll probably just like reuse whatever she said in opening, probably. Buffy says 20 minutes. Yeah. I'm thinking she's not 5 hours. No, Kelly, she did. Prosecution said it was going to take them an hour, and then they asked Lori, and she was like, it'll be less than that, Your Honor. Oh, they got the seal back. Do. Oop, and add that there. She called 0 witnesses. She didn't take the stand. I'm so salty about it. Just disappointed. I mean, if you're going to do it, just do it. Okay? Just go for it all. Why not? I'm here in Austin Lee Edwards Hell prepping for Thursday. Yeah, that case is crazy. I don't know all the details, but I do know like the basic 3 or 4 things about it. It's crazy though. I wonder how many objections. Oh, hold on. It's going to be very noisy for a second. Okay, not so noisy anymore. Her evidence didn't show. Nobody accepted their subpoenas. Nobody. So, oh goodness. I think total opening statements is probably going to be about like 2 hours. Do you think we'll have a verdict today? I do. I really do. But if the closings take about 2 hours, you're going to have about an hour and a half to debate. Though the judge said they could make their own schedule. So I don't know if that means they can stay past open or office hours. So we'll see. But I think they're going to come back with a verdict today.
I hope so.
It's not like they have much paperwork to fill out. Oh, we got noise.
All right, we'll go on the record. State of Arizona versus Lori Daybell, CR 2021-001704. Before our break this morning, the defendant moved to have an exhibit admitted for appeal purposes only. That exhibit number, the correct number, I believe, is 269.
That's what I understand.
All right, so it's ordered that 269 would be admitted for appeal purposes. It won't go back to the jury during their deliberations.
I hope so. I hope it's done today. I mean,
Go ahead and get the jury lined up, I guess.
I hope so, Kelly P. And we're back to the seal. I thought I muted. Could you hear that? Sorry. Brownie, which is
Jury is now present. Please be seated. This is time set for closing arguments. The state can proceed with its closing argument.
July 18th of 2019, just 7 days after this defendant and her co-conspirator Alex Cox shot and killed Charles. This defendant texted her soon-to-be next husband, Chad Daybell, about Charles's life insurance policy. Her words tell us that she was involved in this killing. Her actions and her words of texting Chad Daybell tell us the motives behind this murder: Chad and money. The morning of that 18th of July, Lori Vallow texted Chad and said, quote, "I just got the letter from the insurance company saying that I am not the beneficiary. It's a spear through my heart. Who do you think he changed it to?" Later that day, after she spoke with the life insurance company, he sent Chad another text. Quote, "So I talked to the insurance company. He changed it in March. Probably it was Ned before we got rid of him." Lori Vallow's words 7 days after Charles was shot and killed tells us that we was her and Alex killing Charles. Why? For that money. But Lori Vallow's plan to kill Charles wasn't just known by her lover, Chad Daybell, and her accomplice and co-conspirator, Alex Cox. It was also known by her brother, Adam. Adam told us that he knew about Lori's beliefs. He knew what she had been saying about Charles's concerns for himself. And he told us that he knew about this plan for an intervention, to talk to a stakeholder. That morning of July 11th, when Charles arrived at Lori's house, as she knew he would, he texted Adam and said, "Al is here." Adam texted back, "They are planning something." He knew. And 3 days later, on Saturday, when Adam finally learned, when his friend Googled Charles, that he had been shot and killed by Alex, Adam told us he went back and talked to his mother, and he confronted her about this. And he told his mother, Lori and Alex conspired to kill Charles. He knew, and he was right. Lori's ex-friend, Christina Atwood, she told you about that very uncomfortable dinner on June 9th, a month before the murder, where Alex Cox was talking about just wanting to kill Charles. He said this multiple times, and this defendant didn't care. In fact, She talked about how she had been drugging Charles. Christina told you she was so disturbed by this, she actually went and saw Lori the next day, June 10th, and told her, if something happens to Charles, I'm going to have to go to the police. Christina knew. She was right. And Nancy Jo Hancock. Now, she had just met Charles a few days before, and they had talked and texted and had been on the phone for hours, you heard. Charles had told her all about Lori, the things she was saying, the things she was doing. She told you that she knew that Charles was concerned for his own safety. And she understood the motive. She told Charles the night before, you probably should just tell Lori that you've changed the beneficiary, that she's no longer going to get that money. Nancy Jo knew, and she was right. Lori Vallow wanted the $1 million, and she wanted Chad Daybell. And she and Alex used that twisted religious beliefs they had so that they could kill the evil, possessed Charles and be like Nephi. The evidence that has been presented in this trial will prove to you beyond a reasonable doubt that this defendant is guilty of conspiracy to commit first-degree murder. So I want to split up my closing into 3 sections. First, I'm going to talk to you about the timeline and the motives in this case and the evidence that supports those. Second, I want to talk to you about the jury instructions and the evidence that's been presented to you in court. I'll remind you that anything the defendant said in her opening was not presented at trial through a witness or through an exhibit, and it is not evidence. Using the evidence that has been presented and admitted at trial, the state will show you how, again, the defendant is guilty beyond a reasonable doubt of this crime. And finally, I'm going to talk to you about those justification defenses, the excuses and the reasons why the defendant would like you to believe that they had a valid basis for shooting and killing Charles on July 11th. And we'll talk about how, in fact, there is no justification for what they happened. What happened that morning was a first-degree premeditated execution of Charles Vallow. So let's go through the evidence. The timeline really starts, and we know it goes back much further than this, but the big change occurs on June 29th or 30th, when you learned that Charles Vallow learned about these KK Walker emails. He learned about that affair with Chad. Now he knows Lori is cheating on him. We know that he contacted Chad Daybell about it. He contacted Chad's wife about this. He told Adam about it, and he told the defendant about it. So everyone knew that Charles now knew this. July 9th is now the first time that Charles is going to be coming back to Arizona. We know from the time he learned about that affair, he hadn't been back until this planned visit to see his son, JJ. We know at 1:13 p.m., Charles texts Adam and books him a flight for the next day. At 1:21, we know that Adam is contacting Alex. And they talk for 20 minutes. And Alex lets Adam know, sure, you can stay with me. Of course, Alex doesn't know the plan yet, the mission. Lori then starts talking to Chad Daybell. We know that she knows about this intervention. She knows about Adam coming. And we know this because, again, of her text messages. We see Lori then starting to round up the troops. Why does she do this? Because she wants to ensure that on July 11th, it is Charles and only Charles coming to the house and not the intervention of Adam or Brandon or Zach coming over to help him. So she has Melanie. Tells her she can't go to this wedding. She has to stay here. It's coming to a head. This week will change everything.
Ugh, not great.
Call me. Then we have July 9th, the text messages with Alex. She tells him, so the plot thickens, call me when you can. He doesn't call her initially. So she sends him another message. This one really letting him know. She specifically tells him, I'm going to need you to stay close to me the next couple days. Mel too, she can't go to Utah. She's got a job. They are planking some kind of intervention, but want Mel out of the way, so I'm left alone. He talks, I need to come get the stuff at your house tomorrow and secure it. Lots to do. Thank you for standing by me. It's all coming to a head this week. I will be like Nephi, I am told, and so will you.
I forgot about Nephi.
This gets Alex to call, and they talk for almost an hour. An hour planning how they're going to stop the intervention, how they're going to be like Nephi. As we get to the 10th of July, and we continue through this timeline, we see Lori again talking religiously with Chad. 149 minutes that morning. She's also texting Melanie Boudreau, Melanie B, telling her that it's important for the mission for Melanie to help her by keeping Brandon distracted. We saw those messages where Melanie says she'll pretend to be sick. We know that on the 10th, Adam arrives in Phoenix. And now we have Summer helping the defendant, letting her know what is going on with Adam and Zach. Everyone is covered to ensure that Charles will be alone on the 11th. We have the continuing talks with Chad, her soon-to-be husband. As we get into the 10th in the afternoon, we know that per their agreement, Adam calls his brother Alex. Hey, I'm here. Brother doesn't answer. Sends him a text. I'm here. No response. Why? Because the night before, his sister Lori told him, we have a mission. We must be like Nephi. Charles is coming into town. You must stay at my house the night of the 10th so you can be here the morning of the 11th. We also know that Summer gave Lori an out. Hey, you can stay at my house. No one will know where you are. We're going to be out of town. You can hang out here. Lori doesn't take her up on that. She has a mission to do. As the night grows on the 10th, Adam continues to try to reach his brother Alex. Again, no response. And by 45 or so minutes after that last text by Adam, we know Alex is already at Lori's house. He's there with his gun and a garbage bag of some underwear. Why? That gun is important. A loaded weapon, 2 extra magazines of ammunition with him. He is ready for his mission. And again, Summer is updating her, telling Lori that Zach and Adam are still at her house. They're going to go stay at Mimi's. And she even tells him that Adam is still waiting for Alex to get back to him. Still, he doesn't understand. Why isn't my brother responding to me? I was supposed to stay there. And again, what does Adam bring over? Gun and a garbage bag of clothes. That's all he needs to be part of the mission. When we get to July 11th, we still have Lori talking with Chad. We see those text messages going back between them. And then we start learning from the GPS from Charles Vallow's phone as he arrives. 7:35 a.m. He arrives at 5531 South Four Peaks. That's where we have at 7:36, Adam texting Charles. They are planning something. There is no reason why Alex should be there. And that explains why Alex wasn't responding to me and didn't let me stay there. We see that last outgoing text message by Charles Vallow at 7:37. And in fact, what we see is at 7:37 and 12 seconds, Charles sends out his last outgoing message. And at 7:37 and 29 seconds, there's an incoming message from Adam. It's not read until 12:13 p.m. What becomes important here is in this timeline, how long is Charles at the residence here? You hear in her interview how she says it's so fast. Charles comes inside. He's angry. He's jerky. And she tells him, take JJ. Go get him Burger King. To get JJ out to the car. And then she holds onto the phone. This argument erupts, and it's just so fast. But what we know is it's actually 12 minutes long. This is not a fast incident. In this 12 minutes, Lori Vallow and her brother Alex Cox are doing their mission, and they are being like Nephi. We know at 7:49, it's over. Lori has left in Charles Vallow's car with his phone and JJ and Tylee. We know that there are 2 phone calls between Alex and this defendant after she leaves, as Charles is laying dying or dead on the floor. 7:52, 8:06, they talk. 47 minutes passes before Alex calls 911. 47 minutes to stage the scene. The police are advised when they arrive that the shooting just occurred and that CPR was given. Why is that important? Because you heard even during the interviews, the police were trying to figure out this timeline. Didn't make sense. At 8:48, almost an hour later, Lori Vallow returns. And then we see that around 9:40, she is being interviewed at the Family Advocacy Center. We know that Lori Vallow has Charles's phone that entire afternoon. You saw the PowerPoint from Detective Werther showing that her phone by about 12:36 is already her phone, Alex's phone, and Charles's phone are all in the area of Alex's house out in Santan. You see on her records that she again calls Chad Daybell.
I think she looks like Angela from The Office.
Detective calls her and leaves her a message. They don't leave immediately because what do we know? We know at 2:13, Alex is taking photos of Adam's or flight reservations from Charles's phone. Not screenshots, but photos of the phone. At 2:18, Lori Vallow, who has not told Charles's kids, his family, about his murder, is calling the mortuary.
Suspicious.
A little bit after that, they still haven't left. She's calling Chad again. And then by 3:11, we know that Charles's phone, through the GPS data, is back at 5531 South Four Peaks. And when asked about it, the defendant and Tylee hand it over and provide the PIN. They have no problem on how to get into it. They've already looked through it. They don't need it anymore. That evening, Lori and Chad are talking all night. You can look through the exhibits and see the multiple calls of them discussing. Different calls to Charles's family, they're not calls to his kids, talking with her lover, her soon-to-be husband, Chad Daybell.
I love her suit jacket.
So let's talk about the motives of this case. Money. We see that from the text messages and the anger that you see through them when she learns that that's been changed and she's not going to get it. Chad Daybell. We didn't go through those text messages, but you can look at them. They are already very romantically involved by the time that Charles is murdered. And it's clear that Chad knows exactly what's going on because he's asking her about the car, about the insurance. All of those things Chad knows. And then there's that religious belief system. The zombies, the Z's, the possessed evil spirits. And her being like Nephi. All a reason and a way to kill someone, just like Nephi, a justified killing. There's that first call when we talk about money motive to Banner Life Insurance.
And what was the cause of his passing? Well, he was shot. Okay, so I don't know how I want to put that. Okay, all right. And I hate to ask, but is it? Yeah, you can just say yes or no. Was it a homicide? No, it was an accident. An accident.
So what we hear here is Lori Vallow being untruthful to Banner Life Insurance. We'll talk about credibility later, but it becomes very relevant that even in the smallest of things, this defendant exaggerates, minimizes, and is completely untruthful to various people. We all know that she was not the beneficiary. She didn't. But we also know that Charles Vallow was not accidentally shot. She told the police she was there. She knows that her brother intentionally shot him. Of course, they want to claim it's self-defense. There's no accident about that when you shoot someone twice. Motives for money. What we see again here is Lori Vallow talking to Chad about the motive. Telling Chad about the fact that it was changed. I just got the letter from that insurance company saying I am not the beneficiary. It is a spear through my heart. Who do you think he changed it to? Brandon? Probably Kay? He left nothing for JJ. What do we know? Again, we see that Chad knows about all of these things. And what does he talk about in that morning as you have those entire messages? It was at 2:30. It would be interesting if he got changed after he had 2 bullets to the chest. Again, as we talk about the murder, we have later in that day the message that I talked to you about. So it was probably Ned before we got rid of him. We, not I, not my brother Alex, but we did. And then the other thing in this text message that is of importance is the fact that Lori Vallow knew a month before she went to Social Security how much money she was already going to get for the death of Charles. Here she says, I will still get the $4,000 a month from Social Security. When we talk about that motive and the anger by this defendant over not being the beneficiary, we know that even on July 28th, so 10 days later, she goes into Charles's computer to find the change of beneficiary form. She texts that to Chad to show him, and she sends it to Kay and confronts her about it. Money. That's what she wanted. And Chad. So let's talk about Chad. The affair with Chad Daybell. We know that she knew him as far back as November of 2018 when he came to Arizona and stayed at Lori's house. You were told by Detective Duncan that there were recordings on her Lori for Style iCloud account of Chad Daybell here in Arizona for that Preparing the People conference. You also heard that in the Lolly Time, the later account that was created later, that in March of 2019, there were screenshots of flights to Idaho and back to Arizona with both Lori Vallow and Chad Daybell. This is during that time when she disappeared and Charles was taking care of JJ, and she's off flying to Hawaii and Idaho, living the good life with her soon-to-be husband. And then, of course, we know that come November 5th, she actually marries Chad Daybell. That KK Walker email address. This was that June 29th. Big change. What do we know? That on April 21st, she created that account. She used her own phone number in creating it. And then she sent messages to Chad Daybell, brother Daybell. We have that exhibit. She pretends to be Karen Walker and invites him to Houston, because that's where she is at that time. She offers to use Charles's money to fly him out there, and that he can stay at the house with her and her husband. In June of 2019, we see that Lori again uses that same account, but this time she pretends to be Charles and invites Chad out to Arizona to help him with a book. And again, in Exhibit 289, you have those letters. Charles finds those. And he lets everyone know he did. And he confronts Tammy, lets her know. Confronts Chad, lets him know. And he certainly lets the defendant know that he knows. And now the jig is up. We see in these text messages that were recovered from the iCloud accounts, whether they're under the Bubby context or under the Melanie 2 contact, this relationship between Lori and Chad. If you want to read the story, it kind of mimics them meeting in November, hooking up in hotels, and discussing their love for each other. When we are talking about a motive and a person who wants money and who has not worked for 13 years, who has had her husband pay for her homes, her phones, her cars, allowing her to go to the temple and work out and go to lunch in restaurants. This is a big change in life if she loses all of this. But if she gets $1 million, not so big of a difference, along with that Social Security she'll be getting. And then obviously we know that once Charles was out of the way, Lori and Chad were able to get married. But what about those religious beliefs? Everyone that Lori knew, who she expressed them to, told you that they were not in line with the Church of Latter-day Saints. Everyone told you that she said things like she didn't need to repent, she didn't need forgiveness, she could do whatever she wanted now, that she was in a celestial state, translated, that she is spiritually and physically changing, that she's above the priesthood, that she knew who was dark and evil. You saw those text messages, both about Charles and heard from people, as well as about Brandon and Zach and Adam. People who were helping Charles were also dark or Z's. And ultimately, what did we learn? That she associated herself with Nephi, a prophet, a holy man. who was justified and asked by God to kill Laban because he was an evil, wicked king who had the tablets that God wanted him to go get. Lori was just like that. She was justified in her killing. We heard from her brother Adam that their relationship had ended when she told him some things about her beliefs that he disagreed with. That she was turning into that celestial state, that she didn't need to eat, that she had more authority than the priesthood.
Yes.
You yourself.
What was that yes about? Did you guys hear that?
Aware of Lori?
Yes.
Outside.
But were you aware? Why do I keep hearing? Am I crazy?
No, I heard it too.
Lori having any beliefs that were outside of what is accepted by the LDS religion.
Yes.
Oh,
Can you tell us what you
Okay.
were aware of that you knew to be outside the LDS religion?
Lori told me that she was in the process of translating from a mortal human being to an immortal human being, a celestial state.
who isn't?
That's something that the LDS religion supports?
I haven't heard of it in that it's happened here on Earth yet.
Serena Sharp told us about, again, the not repenting and Lori changing physically and spiritually.
Me either. I'm surprised.
Members of the LDS Church.
Yes.
During this time, did Lori ever tell you things about her beliefs that seemed to go against what you understood or what you were taught through the LDS Church?
Yes.
Did Lori ever tell you that she did not need to repent?
Yes, she did.
During this weekend, did Lori talk to you about her husband, Charles Vallow, being possessed?
Yes, she did.
What do you recall about her talking about her husband being possessed?
I recall that she spoke about her husband being possessed by an evil spirit, and she named the evil spirit.
Do you recall what the
I
name
have
was?
phone in for that.
Yes.
What was it?
It was Ned.
N-E-D? Ned?
N-E-D.
Now, Serena Sharp was someone who met Lori in November, texted or talked with her for a while, and then was invited to that girls' weekend. One of the jury instructions you're looking at.
It is,
talk
right?
About more, though, is the
Weird.
credibility of a witness. Serena Sharp has no dog in this fight. She knew Lori for a little while. She was invited to, I'll call it the inner circle. The defendant told her some things that went against her religious beliefs. And she said pretty much after that, the defendant stopped talking to her. Now, how do we know she's being truthful? Well, we see Ned in lots of text messages. This just helps tell us that this is something Lori was telling lots of people, that her husband is possessed by this evil spirit, Ned. And we learn later that, like Nephi, she can get rid of him.
Do you recall Lori Vallow telling you that her husband Charles was no longer Charles, that he was now this possessed person?
Yes.
When Lori was talking to you about Ned, was she explaining that this evil spirit was now in the body of her husband.
I don't know if she used those exact terms, but that was the impression I got. Yes.
Jeez, that's so rough.
The word she used expressed to you that idea that this evil spirit Ned was now in her husband's body.
Yes.
The other thing that Serena Sharp told us was Lori using that term zombie. You remember how upset the defendant got by her saying that. But again, why would Serena make up any of this? She has no reason to. What she recalls is that that is a term that this defendant used when speaking of people like her husband who were possessed by these evil spirits. We heard from Christina Atwood as well, the same concept that Lori Vallow repeatedly would say.
Did she tell you, as well as the other women who were at this meeting in February, that her husband was possessed?
Yes.
So it wasn't just you in a private conversation.
Correct.
She was open about it.
Yes.
So again, we see this ongoing timing of Lori Vallow talking of her evil, dark husband, who she later is authorized under her religion to get rid of. We know as well from Christina Atwood that there is a progression of these beliefs becoming more deviated from the LDS religion as she is meeting with her between February and June when she finally hears those words.
From the time you started meeting with these gatherings in February through to June, did you start to see sort of a progression of things that Lori was telling you that seemed outside of your faith?
Yes.
Did she make statements to you that you believed went against your religion?
Yes.
Did she at any point tell you that she did not need to repent anymore?
Yes.
What is that? What is that meaningful to you in your religion?
We believe that every single person outside of Jesus Christ has reason to repent.
My God, it's so bad. Like it's literally given me a headache already.
So let's take all of this, the motives and this timeline now, and talk about some of the jury instructions and all the evidence that supports proof beyond a reasonable doubt that this defendant is guilty. I want to start with talking to you about direct and circumstantial evidence. You have a jury instruction that tells you that evidence may be direct or circumstantial, that direct evidence is the testimony of what a witness saw, heard, or otherwise sensed, and circumstantial evidence is proof of a fact or facts from which you may find another fact. You're told the law makes no distinction between direct and circumstantial evidence. And this is relevant. The witnesses have often been questioned. Did you see, hear, or do that? What you are told is you can actually use circumstantial evidence to convict anyone. But let me give you an example of this. Imagine you are sitting on a beach. Just you, it's quiet. Off to your right, there's some rocks and you can't see around that. While you're sitting there, a person walks by, you watch them walk by and they go around the rocks and you can't see them anymore. And then someone runs up 5 minutes later and they say, hey, did you see someone come by here? You say, well, yeah, I just saw them walk that way. That is direct evidence. You saw it. Now imagine you're on that same beach and it's completely empty. You close your eyes for 5 minutes. Just relax. Before you closed your eyes, the beach was completely pristine. And when you open them up, now you see footprints. You can see the toes facing off to your right, the heels, and you see them go all the way around the rocks there. Somebody again runs up 5 minutes later and they say, hey, did someone come by here? And you go, well, I mean, I didn't see them, but they must have gone by in the last 5 minutes because you can see their footprints. They went that way. That is circumstantial evidence. you can infer from that that someone went by and where they went. The burden of proof. The state has the burden of proof, as we absolutely should. So let's talk a little bit about what it is and what it is not. You're told that the burden of proof is proof beyond a reasonable doubt. And the instruction tells you that that leaves you firmly convinced in the defendant's guilt. You're told there are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find him or her guilty. So I want to start by saying what proof beyond a reasonable doubt is not. It is not proof beyond all doubt. It is not proof beyond all conceivable doubt. It's not proof beyond all possible doubt, and it's not no doubt. You're told that there are very few things in life we know with absolute certainty. So just because someone says, what if? That is not a reasonable doubt. What you're told is it's proof beyond a reasonable doubt. As we go through the evidence and apply it to the crimes, we will show you that there is no reasonable doubt as to this defendant's guilt. So let's start with the crime itself, conspiracy to commit first-degree murder. There are three stages in this, or three things the state must prove. One, that the defendant or her co-conspirator caused the death of another person. Well, we know that Alex Cox shot and killed Charles on July 11th of 2019. Alex called 911. Alex indicated he was the shooter. He was the only one home. It was his gun. His credit card or debit card was in there with the gun. And we know that Lori told the police that her brother killed Charles. So we know that he caused the death of, so that. Two, that they intended or knew that she or a co-conspirator would cause the death of another person. When we are looking at this case, we are looking at the defendant's words, actions, and motive. The words and actions of having her brother Alex come over on the 10th with a gun so that he would be there when Charles came over to pick up JJ. The actions that day of taking Charles's phone, ensuring that he could not leave, that he could not take his son to school. The defendant told the detectives how angry and screaming Charles was about the phone, but she didn't just give it to him, throw it at him, tell him to get out, whatever you might do. She held onto it and told the police that she walked away with it as he's trying to grab it. The defendant's actions and words show us that she is the only reason why Charles stayed in there and the only reason why Charles was shot. Then there's those 12 minutes. Defendant tried to pretend that this was a quick, angry scuffle. But Charles is there for 12 minutes. The defendant is there for 12 minutes. Alex is there for 12 minutes before she leaves. We look at her actions when she came back. She told the police her brother was hit in the head with a bat. She never asks how he is. She's not concerned about his injury. She's not concerned about her husband being dead on the floor of her house, her child now without a father. The lack of words that she said there and her demeanor show again that she was well aware of what was going on and part of this incident. We look at her words to Chad, that Charles changed his life insurance policy before we got rid of him. They show her intent to kill Charles. And again, we look at the motive, money and Chad. When did this happen? The first time Charles came back into town after he found out about the affair. Finally, the state has to prove that the defendant or the co-conspirator acted with premeditation. So I'm going to talk to you about premeditation. You have a jury instruction for it, and it tells you that the defendant or the co-conspirator intended to kill another human being, or knew she or the co-conspirator would kill another human being, and that after forming that intent or knowledge, reflected on the decision before killing. It is this reflection, regardless of the length of time in which it occurs, that distinguishes first-degree murder from second-degree murder. You're also told an act is not done with premeditation if it is the instant effect of a sudden quarrel or heat of passion. It's where you remember those 12 minutes and the calmness of her walking around with that phone and her demeanor. You're told the time needed for reflection is not necessarily prolonged, and the space of time between the intent or knowledge to kill and the act of killing may be very short. So I'm going to give you an example. It's a lot of legalese, and then we'll talk about what we really have here. So imagine again, you are driving your car. You do every day. You're coming up to an intersection and you see the light turn yellow. And in that second you think, do I want to run it? Or do I want to slam on my brakes and hit stop before I go into the intersection? You think about that, and then you decide, I'm going to slam on my brakes and I'm going to stop. That is the time it takes to reflect. That is the time it takes for premeditation. But we have a lot more than this, because we have planning, not just premeditation that morning. So when we talk about the premeditation that we see, it starts at least back in June, when we have Christina telling us about Alex Cox saying that he wanted to kill Charles, Lori having no reaction to that, and instead talking about drugging Charles.
Did you hear Alex making some comments?
Yes.
And you told us that they made you uncomfortable. What were these comments?
He stated he wished that he could just kill Charles.
Okay. Was Lori around when he's saying this?
Yes, one of the times.
Okay. So he said it more than once.
Yes.
Can you describe for us part of his demeanor when he's saying this about wanting to just kill Charles?
It was jocular, just as I recall, he was standing up and just talking about it pretty loudly.
And you said one of the times that he said this, it was around Lori.
Yes.
Did she react in any way to hearing her brother say that he wished she could just kill her husband?
Not that I recall.
By July 9th, or when we start having this planning that we're talking about, we know that Lori Vallow is living in a house paid for by Charles Vallow. We know from even her statements to Detective Enclan that she doesn't like Charles, is what she says, but Charles won't file for a divorce. We know from her words and text messages that she wants to be with Chad Daybell, but Charles is her cash cow. She hasn't worked. She pays rent, car, cell phones, her travel. And so as far back as June 9th, we're already hearing that Alex and Lori would like to not just get rid of Charles, but kill him. But if you think that June 9th wasn't the beginning of this planning, this idea, this concept that Lori and her brother have of getting rid of Charles, this evil, dark, possessed person, that we know on the 9th that there is definitely a plan by this defendant. And we see that through those text messages with Melanie, with Summer, with Alex, where she speaks of the mission, where she talks about telling Melanie, you can't leave. You got to pretend to be sick and stay here and keep track of Brandon so he doesn't come help Charles. He can't be in the picture. We need to stay here to defend ourselves from an intervention. The 10th, again, we have Melanie who is talking to her and saying, that she wants to just go to this wedding. And what does Lori tell her? No, you have to stay here for the mission. The mission of stopping an intervention? No. As we continue through the 9th, we see Lori getting everyone lined up to help her. Alex, where he again is told that he will be like Nephi, just like her. Now Lori tells him it's an intervention. Everyone knows, Adam told you what's an intervention? Talking to someone. It's common language. But that's not what the defendant wants to happen. She doesn't want Charles to divorce her and lose his money. She doesn't want this intervention to happen where she loses her temple recommend. What she wants is to be like Nephi and get rid of her husband.
Mm-hmm.
Well, Nephi was a prophet in the Book of Mormon. It's the first chapter. He is a prophet, very humble and faithful servant of the Lord. Ironically enough, his brothers tried to kill him at one point. But he actually ended up going to Jerusalem to get these plates back, and he was run off, came back, and then went back again because the Lord asked him to. And when he did, the King Laban, who was actually a wicked king, was laying on the ground drunk in front of him, and Nephi was told to kill Laban.
Who was he told by?
The spirit, or God.
So God was using a Holy Spirit to tell him to kill Laban, and
Yes.
did he?
Yes, he did.
Is that something he anguished over?
Yes.
But ultimately, it was a justified killing.
Yes.
You heard from Detective Duncan that everyone he spoke with gave this same story. And again, the defendant questioned others about this story. But what we've heard is from Detective Duncan and from Adam that Nephi is this justified killing. When we think about her religious beliefs and what she's been telling people about not needing to repent, about telling people who is dark and evil, a zombie or a Z, that she is above the priesthood, it makes sense that she feels justified in determining who should live or die. Just as she told her brother on the 9th. And we know that in fact we're talking about a justified killing because Alex brought a gun over. He didn't bring the Book of Mormon to talk to Charles about something. He didn't bring a friend to try to record Charles saying something. He brought a gun with him. And then he waited there for his sister's husband to come into the house so he could kill him. What we see is a very planned out, premeditated murder. But Let's talk about some additional premeditation. Again, as we're looking at Summer, we see on the 10th that Lori is having her sister update her on where Adam and Zach are staying, so she knows they're not with Charles. They're not coming over. They're not going to be interfering with their justified killing. And there's that 12-minute time where the defendant desperately wanted to rewrite the timeline as they told the police that day. This just happened. It was very quick, but it wasn't. It was 12 minutes. Charles arrives at 7:37 and Lori leaves at 7:49. During this time is when that plan, that premeditated murder occurred. So let's talk about that as well. The evidence at the scene, the physical evidence, supports this premeditated murder. Alex fired 2 shots. One of them went through Charles' center mast, exited out his back, and went into the floorboard. The second one, Charles was on the floor, on his back, bleeding out, still able to move, and we know that because he had blood on his left hand, and he was executed as he lay there on the ground. In that time, when we talk about premeditation and reflection, as Adam had to move his hand down, reposition the gun, and discharge and pull the trigger one more time, that is premeditated first-degree murder, no matter what you believe before that. Again, when we talk about that physical evidence, we saw the fact that the location of that bullet defect in the ground matched right under Charles's left shoulder. And we heard from Dr. Baumgartner. Dr. Baumgartner told you that this was a classic shored wound. And no matter how many questions could be asked about him of maybe a bamboo shirt might stop a bullet in one location but not in another, or how many matrix-like hypotheticals where maybe Charles bounced back up and then on his way down, the bullet slowed down through him and waited till he hit the ground again before it exited. Dr. Baumgartner told you, no, those hypotheticals, those issues did not make sense. He's never seen a t-shirt stop a bullet in one location or at all. And we know Charles didn't bounce because we know he had no injuries to the back of his head. This also tells us a little bit about the shooting itself. When Charles was shot that first time through center mast, he did not fall straight back and land onto the ground, laying there on his back. If he had, he would have had bruising, abrasions on the back of his head when he hit the ground. He didn't have anything on the back of his head. Where did he have abrasions? On his knees. When he fell to the ground after being shot, do we know how long it took him to roll over, to fall onto his back before he was then shot a second time because he's still alive? You heard it could take up to 2 minutes for Charles to have died, and then he could have spoke and moved during that time period. What we do know is that he eventually ended up on his back. And while he was on his back is when he was shot the second time by Alex. This defendant and her brother in that house waiting and making sure that Charles was dead, murdered, executed. Words, actions, motive, and physical evidence all tell you what happened that morning. So let's talk about conspiracy. And I know there are a lot of layers here, and I'm just building them up for you. You're told in your jury instructions that conspiracy requires proof. One,
I think she's
the
starting to
defendant
wrap it up.
agreed with one or more persons that one of them or another would engage in certain conduct. So again, we look to Lori Vallow's words. What she had been talking about for months, Charles being possessed, being dark, wanting to kill him, the discussion on June 9th, poisoning him or drugging him previously. And then when we got to July 9th, it is all coming to a head. We will be like Nephi. Her actions, having Charles come to the house, instead of him staying there, she had him stay away. Why? Because if Charles stayed at the house, couldn't have Alex come over with a gun and be ready to shoot him, right? You got to have him come in. Her actions of inviting her brother over with a gun the night before so he would be there. She knew when he would show up. He texted her, "I'll be there at 7:30. Pick up JJ." But most importantly, why did Charles stay in the house? Lori told the detective that Charles initially was like, "Oh, I'll just stay here for 20 minutes and then I'll take JJ to school." Well, she wasn't going to kill him in front of JJ. No, take JJ to Burger King. Get him out of the house. Go put him in the car. And he does that. But then she takes his phone. And she won't give it back. What she told the detective was, before this alleged Tylee bat, whatever thing you want to talk about there, that she had Charles's phone and was asking him about texting Adam. Of course, that's interesting because how would she have known that? But we know she had the phone actually for a while before she did that interview. She tells the detective numerous times that Charles is telling her to give him back his phone, and she will not. That she's walking around. He's trying to get the phone. She won't give it to him. Why? Because she needs Alex to come out. You brought that gun over for a reason. So she agreed with one or more persons, her brother, Alex, that she intended to promote or assist the commission of such conduct. Well, of course, we know both the promote, she is the one who on the 9th said, "We will be like Nephi. It's time to stop this whole thing. Charles trying to take my temple recommend, all this stuff that's going on. Time to kill him." And of course, she assists by ensuring that Charles stays in the house when she takes that phone. And of course, they knew that it would constitute first-degree murder. That's what Nephi did. Only unlike Nephi, where it was justified, here, ladies and gentlemen, this murder was not justified. Finally, think about the demeanor when you're thinking about, again, words, actions, motive, and demeanor. When Lori comes back to the house, she is very, what did we hear that word many times? Nonchalant, calm, no questions about her brother, no questions about her husband, no questions about the house, just laughing about her neighbors. She is in absolute agreement with what has happened. She knows what's happened and she's calm and good with it because she doesn't need to repent. She is able to determine who should live and die, and she has done that. So when we talk of the scope of conspiracy, You're told that to prove a conspiracy, it is not necessary to show a formal meeting or express agreement. But we see that from the 9th in that conversation that she and Alex had, where she tells him, you are going to have to stay near me for the next couple days, and we will be like Nephi. You're also told that a conspiracy may be inferred from circumstances showing a common criminal objective. So, because you don't have someone who says, I heard them say, we shall conspire, you can infer that from the conduct of what happened on the 9th, the conduct of what happened on the 10th, and the conduct of what happened on the 11th. All infer to you a conspiracy of Alex coming over with his gun to shoot and kill Charles. As we again look at this in this conspiracy, again, we're looking at the same words and actions. March, Charles is no longer there. There's just an evil spirit in his body. June, Charles is still possessed, and now Alex is saying he wants to kill him. Lori is fine with this, and she says she's drugging him or had been drugging him. And then 2 weeks before, all of a sudden, Charles knows Lori's been having this affair. Lori's words, actions, motive, and the physical evidence.
Oh, come on, Trina.
Conspiracy again, we see that Lori and Alex know exactly when Charles is showing up. Alex doesn't go to the door according to Lori and confront Charles or tell him we'll send JJ out and you can leave with him. The world is so difficult. How hard would that be? Bring JJ right to the door and let him leave with his dad. No. You aren't going to shoot him outside. You want to make it look like self-defense inside. As you go through this and we think about what's going on, the defendant doesn't even care. She wants her husband killed so bad that she's willing to let her brother bring over a loaded gun in an unlocked gun case in a house with a 7-year-old autistic child. That's fine.
All right.
When the defendant was questioning Detective Enclen, she was talking about how hot it was outside. JJ's out in the car. But she has no problem with an unlocked gun in the house with the kid, and she's worried about her child out in the car. She's not. We know that because she's the reason Charles doesn't go back out into the car and leave. She keeps him there in the house. She is why JJ's out in the car alone. She has to keep him there until Alex comes out and can shoot and kill him. When we talk about that premeditation, obviously we're talking about that message. We know from the 9th on, they are premeditated, they are conspiring, and it's all heading to July 11th. We look at the timing of this, and this is actions and non-actions. Charles is in the house for 12 minutes. After those 12 minutes, they wait 47 more minutes before they call 911. Why? To stage the scene. No CPR is performed. They wait for Charles to be dead, and then they talk during this time period. They talk. They could call 911, but nope, they're going to just talk. So again, you're looking at their actions, what happened and didn't happen, and the motives. There's the gun that was used to kill Charles. We're going to go through a couple of these exhibits, some of what Lori said, and it's exhibits 192 and 197, where she again says that Charles came over and said he was just going to hang out at the house for like 20 minutes, take JJ to school. She, of course, tells him to go. And when JJ is out in the car, she has Charles's phone. but she won't give it back. And no matter how much she says that Charles is screaming at her to give the phone back, she won't. And all of this conversation about Charles demanding the phone back is prior to her statement to Detective Enclin that Tylee comes out with this fact. This is all her doing. This is her as an accomplice assisting and promoting this murder. Lori is setting up Charles so Alex can shoot him.
And with JJ?
And so he put them in the car,
Okay.
in the driveway, and then he came back in. Right, so I kissed JJ goodbye. He came back in, and his phone was on the counter, and I had his phone. And he was like, give me my phone. And I was like, why don't you show me your text that you've been texting, blah, 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 you know, whatever. Because he's like acting really weird, like he's plotting something against me. Like, why are you even here? Like, what did you come here for? You know, he's been talking to my
Right,
brother,
it is.
My brother came into town at the same time last night, and I haven't talked to my brother in a while, my other brother, and I was like, and so he was texting him on the phone when he first got to my house, and I'm like, why are you texting Adam? Like, do you even talk to him? Like my other brother.
So when you listen to these interviews of Lori Vallow, you have to put into context, this is 9:52 in the morning when this part of this interview is occurring. And she's telling the detective that she confronts Charles about texting her brother Adam. Now, she's had the 47 minutes she's been driving around, and then that time at the house when she's waiting outside to learn all of those texts and what's been going on between her brother and Adam and Charles. And so she is now mixing this in to her interview. And so when you're listening to her interview, we know she's trying to work out this, what happened? How did this go? You can watch her demeanor as well. And as you're going through this, see how she's just telling a story here, like what happened, almost chuckling about it.
Okay. So this morning he comes back in and...
He comes back in, I haven't given his phone, he was screaming at me to give him his phone. He was very worried about whatever was on his text that he did not want me to see. And so I was just holding it there and he was screaming at me. And I was kind of walking towards around the house with it so he couldn't get it. He's like reaching for it and stuff like that.
So again, JJ's in the car, Tylee's not out, Alex isn't out, and she is making sure that he doesn't leave. She's walking around the house, holding his phone, refusing to give it to him, making sure her autistic child is sitting out in the car even longer so that she can ensure that exactly what they've been planning happens, that Alex has time to come out with the gun that he brought over and shoot and kill Charles. This defendant is the only reason why Charles didn't leave with JJ. This defendant is the one who provoked Charles by taking his phone and refusing to get it back. This defendant is the one who ensured that Charles was inside without JJ so Alex could shoot him. And this defendant is the person who set up Charles so that her brother Alex could shoot him. Let's talk about staging the scene. We know obviously from the first responders that when they arrived, no CPR was given. You heard from Officer Wierzbecki that when he felt Charles's neck, he thought he was dead already, but they still let the first responders in because they've been told CPR had been given. And what do we know? That they arrived within a few minutes. No one had ever tried to save Charles. No blood had been pushed out of him from CPR, whether strong or light. He had been dead for quite a while. His skin was mottled when they started cutting open his shirt and looking to the back, and lividity, the blood pooling, was occurring already. So they kind of knew something was off with that timeline. So what about the scene itself? The bat. It is placed to the right of Charles to look like he was using it. got shot and went flying behind him. Well, obviously, we've heard from Kay, Charles's sister, that he was left-handed. We know from the blood evidence on his hand, he was left-handed. There's no damage to that mirror. There's no damage to the drywall. There's no damage anywhere, like this bat is being swung around in this horrific fight that's going on of grappling. The injury to Alex Cox's head. You heard it was a small 1-inch cut that he was using a paper towel to pat in at times as we watch that Exhibit 1, rubbing it, making sure it stays bleeding. There is no blood at the scene from this giant grappling thing going on that Lori Vallow wanted them to believe. His head is bleeding and they're grappling around and he's being beat with this bat, and yet not one drop of blood on the floor. Not one drop of blood going down the hallway when he put that gun away. Not one drop of blood on the gun itself. And then the shoes, left by the door to look like Lori Vallow had run out in fear after this horrific incident that they planned. But we know from the Walgreens video is that she did enter the store with shoes, something on her feet. So we're going to go through. We know Charles, again, left-handed.
With your brother. Yeah. What position did your brother play?
He was a pitcher. He was very, very good. He was a left-handed pitcher, and they're very hard to hit against.
Okay. Did he bat right or left-handed?
He was left-handed.
Did he do everything left-handed?
Yes.
Left-handed? So we know that Charles batted left-handed, not right-handed. And what we know is Lori Vallow had a story about how Charles was using that bat. And it becomes very important as well when we're talking about the staging of the scene. This is Exhibit 193.
Yeah, she was outside, and what happened? Then they got up from that, and my brother had like stepped back, I guess, and then Charles was coming with me to that, yelling at me to give him his phone still because I had it in my hand. It was all really quickly, and then when I went around kind of in the circle, then my brother was there.
I know, right? Oh,
When you said when you
the
were
worst.
going around and he was coming at you with the bat, how was he holding the bat?
Just like that, like backwards.
Like he was swinging it backwards? He would have done like
he would have swung it backwards at me, not frontward.
Okay.
Detected and planned that Charles is swinging the bat backwards. Now, if the bat was like this when he was shot, his arm would have been shot. Covers his center mass. So we know he wasn't here. So if he's out here, where would the bat go? Down, out, somewhere that way to his left. It would not end up thrown up above him. And if it wasn't there again, Charles would have been shot through the arm. Obviously, Alex forgot that Charles was left-handed. So when he placed that, like he was coming at him with a bat, their stories didn't quite match up with the evidence. So if we rely on Lori's story of how Charles was holding the bat, then there's zero way that that bat would end up where it ended up. And again, we know he's left-handed from not only Kay, but his own admissions of that blood on his hand. So we see the scene is staged, this bat that is so necessary to try to ensure this justified killing is legally justified and not just.
She said this was going to be an hour. Girl. It's like an hour and 15
When we
minutes.
talk about the scene as well, you're looking at where Charles was, at least when that second shot went through him. You can see in
The jury's getting
photograph
sleepy.
to the right,
I'm
shot
getting
to Charles's
sleepy.
chest, right
I already got a
between
glass
his
of
nipples.
wine just to
and the shot to
take care of
Charles's
this headache
abdomen down lower.
from awful noises.
We know that that first shot through his chest, that Charles would have been facing a little more towards the open area there where we see the hallway and the kitchen. We know that because there was the bullet trajectory Detective Cruz told you about that entered that far east wall. We know there was stippling, and so the defendant would have been, well, her brother would have been within 2 to 4 feet of the muzzle of that gun, within Charles 2 to 4 feet. We know from the lack of that injury to the back of his head that he didn't fall straight back. We know from the blood on his hand that he was still alive after he was shot. And we know the lack of stippling for that shot to his abdomen and that trajectory, and even the defendant's own statements that she saw her brother at Charles's feet, that he would have stood there at Charles's feet when he fired that second shot as he was laying on the floor. You have the bat, Exhibit 249. You look at the edge of it, you see the photograph of the edge of it. There is no blood and no damage to this bat.
I mean, fair.
Regardless of how many times the defendant was hoping that blood was invisible, we have all cut ourselves and seen that blood is red. And there was no blood on this bat. There is no blood on this bat. There is no damage to this bat. So you have a semi-professional baseball player who has a bat in his hand, and he sees someone with a gun and doesn't beat him with it, take his head off with it, knock him unconscious with it. Instead, all we see on this bat is 0 damage and 2 partial prints. No prints of a body or smushed skin on it. Someone that's sweating from a fight that's left a large arm print on it or anything else. Nope, just 2 partial little prints on it. When you think about what is there and what isn't there, does the evidence of this bat fit in at all? It doesn't. We look at Charles's watch. No damage to it, no scratches to it, no dings to it as he's grappling on the floor like Lori wants you to believe. We know that at some point, Charles is standing and shot, and we know that final shot, he's on the ground. We know he fell to his knees at some point. And when you look at that physical evidence and the lack of damage or anything on that bat, again, what makes sense is that Charles fell to his knees after that first shot. We know that there is 12 minutes where the defendant and her brother are still together there, so that Alex can get this 1-inch cut to the back of his head that's barely bleeding, that he uses a paper towel to dab at and rub. The shoes that the defendant ran out of on her way out. You have the exhibit. You can see black straps across her toes as she enters and exits the Walgreens. And then you see that she's wearing the flip-flops when she comes back to the scene. What do we know? That the police did not search Charles's rental car. Credibility. You are given a credibility instruction and you use it for everyone, including the defendant. You're told that you really evaluate people the same way. You're looking for any inconsistencies in their stories, any reasons why they may have a motive or bias to lie, any prejudice they may have, and then you look at everything in light of reason, common sense, and experience. When you think of the testimony of the people who come here and talk to you, Christina Atwood, Serena Sharp, Nancy Jo Hancock, Adam Cox, Dr. Bumgardner, the detectives, Robin Smith Scott, Mark Zari, What benefit do these people have in being untruthful to you? They have body cameras, they have prior documents, and they have memories of what this defendant said. But the credibility of Lori Vallow is something you do need to consider. You start with her demeanor that day where she wasn't worried about anything when she arrived. Her brother has allegedly been hit in the head with a bat by her husband who plays semi-pro ball. She doesn't even worry about him. She knows he's not hurt. He's fine. And why does she know that? Because that was staged. When she's there and we see her on body cam arriving, just nonchalant and calm. And I know the defendant wanted to make sure that it was clear that everyone else was calm, but no one else had just allegedly seen their husband get shot and killed by their brother. When you were looking at the reasonableness of her testimony, you have to consider it in the light of reason, common sense, and experience. And the way that she was acting and reacting that day, as well as her own statements, do not fit the evidence, do not fit the physical evidence. And you will see her credibility throughout this whole case has been questionable.
Land the plane.
What did we learn? That on July 11th, she tells Detective Enclan that she and Charles are separated. Exhibit 187. We are not living together. Charles rented her house. We're separated. But on August 12th, when she needs to make sure she gets some money, she tells Social Security, when they ask, are you living together at the time of death? Yes. You also learned that she was not truthful with Social Security when she got remarried. She did not tell them about that either. So we know she's been untruthful to Social Security twice. Why is that relevant? Because you're judging the credibility of Lori Vallow throughout all of this. Life insurance. We know that she said Charles was accidentally shot. We know that was not true. She wanted to make things seem like she had nothing to do with the murder. But we know that Alex Cox intentionally shot Charles. Whether or not she wants to claim it's self-defense or not, there was nothing accidental about shooting him twice. Then that second call to Banner Life Insurance, where she tells Robin Smith Scott a few different things to garner sympathy, and she asked her if she could do anything about the change in beneficiary.
I really can't give too much information, but I can tell you that the beneficiary was changed in March of this year. Okay. Okay, I'm trying to figure out what he was doing since we have 5 kids and we've been married for 15 years. Oh, I'm sorry.
So Lori
I feel that way about this, ladies.
We have 5 kids, which if you want to count them all and admit that 3 of them are adults, then okay. Really, they have one kid in common. Tylee, you learned, was actually getting Social Security survivor benefits from her dad's death starting in 2018. Lori's son, Colby, isn't living with them. Charles' son's never lived with them. Why does she say these things? She can't help it. She just wants to just make herself seem better than she is.
It's true.
What about the credibility of her interview, even during the police interview? We talked about a few things, but one of the things she told the detective.
And I didn't file anything or whatever. And then he filed something against me and said, I'm only going to get supervised visits because I'm crazy and blah, 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 you know, the story. And so I just didn't talk to him for like 30 days and let him take care of him.
I don't think so either. Maybe.
Again,
If they let him go late,
Be
maybe.
honest and say 2 months. She got 30 days. I was kind enough to just leave my husband with my son for 30 days. What we know is that Lori Vallow was gone a total of 78 days, 58 while she's flying to Hawaii, going to Idaho and back with Chad. And who's taking care of JJ? Charles. And Kay is coming here regularly to help take care of JJ, to help run the business. And that eventually on March 28th, That's when Charles finally decides he hasn't been able to find Lori. He doesn't know where she is. He's going to move to Houston to be closer so his sister can help him more easily. And this is when Lori finally shows back up. So again, even the simplest thing of just trying to be honest about how long she's been gone, she has to minimize it and make herself seem better.
You with your cross.
The shoes. If this will play. When she was questioning Detective Enclam, she was asking her if it was hot in July and if she would need shoes to go take her son to school. But of course, what we know is that we saw her with those shoes on as she went into Walgreens. So again, it's continued trying to garner sympathy and just being untruthful about whatever she feels like being untruthful about. And then we look at the credibility in that timeline, that body cam.
Brace yourselves. It's going to be loud.
You know, now that you're not in Santan, this is your home.
Right,
Yeah.
We just moved in here.
Gotcha. How long have you guys lived here? How long have you lived here?
Like 3 weeks.
Oh, geez. Yeah. Okay.
That's why the neighbors took us.
Am I crazy? Did we not see this during the trial? Am I crazy?
Are you working?
So here she
I think we
is,
did. Oh.
47 minutes after leaving the house, laughing and smiling with the detective about the fact that her husband is dead inside the house. Her brother is sitting on the curb, allegedly with this very serious injury from a baseball bat. When you look at that credibility of the defendant, you have to look at everything together and what fits, again, with the physical evidence and what doesn't. Finally, let's talk about the justification defenses.
Finally. You guys hear that?
What we know is that Lori Vallow thought she was like Nephi, that she was justified in killing Charles. That her brother, who was supposed to be like her, was also justified in killing Charles. But Lori Vallow is not justified under Arizona law, nor is Alex. So let's go through the different justification defenses. First thing that you have to consider for every one of these, self-defense, defense of a third person, or crime prevention, is the non-justification for use of deadly physical force. You are told if a person is not justified in using or threatening physical force or deadly physical force against another in response to verbal provocation alone. So Charles yelling and screaming at her to give his phone back does not justify you shooting him. Or a person is not justified in using or threatening deadly physical force if the defendant or co-conspirator provoked the other's use or attempted use of unlawful physical force. So we know here Lori provoked Charles by taking his phone and refusing to give it back. So again, when we look at every one of these defenses, you'll see not only do they not apply, but none of them is the defendant entitled to. This is not self-defense. In self-defense, you're told that a person, a reasonable person, can use deadly physical force if they believe that deadly physical force was immediately necessary to protect against another's use or apparent attempted or threatened use of unlawful deadly physical force, and the person used or threatened no more deadly physical force than would have appeared necessary to a reasonable person in this situation. We know that Lori Vallow used Charles's phone to get him to come back inside, and she used his phone to keep him inside and give her brother time to come out and shoot and kill Charles. We know from the physical scene itself that Charles did not use a bat. We know from the physical evidence of Alex's 1-inch cut to his head and the lack of blood or concussion, the lack of damage to the mirrors, the walls, the location of the bat in relation to Charles, they all tell us that Charles did not use a bat. We know that Charles was a semi-professional baseball player. This would not have ended that way if he had had a bat. But even if you somehow think that he did have a bat and he was swinging it at Alex, the defendant, whoever,
Yes.
still was not justified in shooting him when he was on the ground. It has to be immediately necessary to protect against another's use. When Charles is on the ground and he is shot that second time, there is no threat to anyone. And so that is not self-defense.
Counsel, I need to give my court reporter a break unless you think you'll be done in the next 5 minutes. Okay, go ahead.
When we look at the physical evidence, again, we know.
Thank goodness.
Charles was on the ground, shot, and so this is not self-defense. And we know from the physical evidence at the scene, projectile into the floorboard, this is not self-defense. Third party. You're told that a person is justified in using or threatening deadly physical force in defense of a third person, I presume here, Lori Vallow. If a reasonable person in this situation would have believed that deadly physical force was necessary to protect against another's use, again, of unlawful deadly physical force against a third person, and they used only what was necessary for a reasonable person under the situation. What do we know? Lori Vallow told Detective Enclan that she wasn't even in the room when she heard the shot, that she had gone around into the kitchen. Who's he protecting at that point? What third person that's no longer there is he protecting? You can't protect against a future, what might happen, or what already occurred. It has to be now. And Lori Vallow herself put herself outside the room when her brother shot Charles. So there is no third party defense. But again, the same thing applies. Even if you thought so, that second shot removes any possibility of being justified. Crime prevention. This is the exact same thing, only in a slightly different stated way. But like self-defense, it allows a person to use deadly physical force against another to the extent a reasonable person would have believed that deadly physical force was immediately necessary to prevent Charles from committing aggravated assault against Lori Vallow. We know she's not in the room. Even if he had that bat and had been coming at her and then she left the room, that crime is over. And again, even if you believe he had the bat, you cannot shoot him while he's on the ground. That is not what crime prevention permits you to execute a person. Finally, there's mere presence. You're told that guilt cannot be established by a defendant's mere presence at the crime scene, mere association with another person at the crime scene, or mere knowledge that a crime is being committed. Lori Vallow wasn't just present at this crime scene. She brought her brother to the crime scene. She ensured that he brought a gun with him. She ensured that JJ was outside, and she ensured that Charles stayed inside. She was not merely present. She was a person who was actively participating in this crime. Ladies and gentlemen, we have talked about the evidence in this case. Evidence that was presented to you through witnesses who took the stand and exhibits that were admitted for you to review. Remember the evidence of Lori Vallow's motive. Charles's life insurance, Chad Daybell. Remember Lori Vallow's own words of wanting to get rid of Charles, of drugging him, her acceptance of her brother's statements that he wanted to kill Charles, how she used Melanie and Summer to plan her mission and ensure that Charles didn't have help, than Brandon or Zach or Adam. Her words to Alex about it all coming to a head, that he had to stay near her and they would be like Nephi, justified in killing Charles. And finally, her words to Chad Daybell on July 18th, confessing to the killing when she said Charles had changed the life insurance before we got rid of him. Look at her actions and demeanor, having her brother come over on the 10th to her house with a loaded .45 caliber handgun, creating the one and only reason why Charles stayed inside the house, why he didn't just take JJ to school. The 12 minutes that Charles is at the house before Lori leaves in the car, the 47 minutes after that before they call 911, her demeanor when she comes back.
Longest 5 minutes
caring that
ever.
anyone has been hurt.
Oh my goodness.
Her demeanor on the body-worn camera.
The Jerry
during
needs
her
a break.
interview, what you heard about during the
Oh, there. I
drive.
bet they take a break.
Think about her credibility, how she cried for you in her opening statement. You certainly didn't see her cry on that body camera footage. You didn't hear about her crying as she was being driven to the Family Advocacy Center, and you did not see her cry in her interview. Finally, think about the physical evidence that proves that Lori and Alex staged this scene, that Charles was never in possession of that bat when he was shot by Alex or either of the shots, that instead he was executed that day for this defendant's benefit. The physical evidence disproves beyond a reasonable doubt that Lori Vallow and Alex Cox were justified under the law in killing Charles.
Yay.
The jury instructions tell you to use reason, common sense, and experience. Charles Vallow is dead today because this defendant and her brother
This is
Alex
crazy.
Cox conspired to kill him.
Wow.
They planned it out, and they had their weapons, and they orchestrated a way to ensure that Charles was back in the house where he was shot and killed for money and Chad Daybell. The evidence proves to you that Lori Vallow Daybell is guilty of conspiracy to commit first-degree murder, and the state asks you to hold her accountable and find her guilty. Thank you.
Ah,
Thank you.
thank you, Trina.
All right, we're going to take our 15-minute afternoon recess. I'll remind the jurors to remember the admonition. We'll resume in
Good
15
Lord.
minutes.
Oh my goodness.
Quality.
Magic. Then you've been brainwashed. Join the llama cult, they say. Oh my
Soon you
goodness.
should be quoting Star Wars or War Star.
War stuff. Jeez, Tina girl. I mean, don't get me wrong. Like, she covered all, like, I think she did a really good presentation of the facts. I'm sorry. But, like, girl, I have a little bit more personality to that because I stopped giving a shit after about 40 minutes. And I'm sure that the jury did too.
Some, like,
Oh,
you know, inflections or fluctuations, something. Good grief.
mhm.
I had to go get
I mean, she
soda.
clearly knows the case. The whole time, she clearly knows the case. I mean, she wasn't really looking at notes, like she was ready to go, but just like, oh my god, it was so long, so long. Star Potter and Harry Star, Terry, I'm gonna get you, girl. I'm gonna get you, girl. Oh my goodness, and the audio on those. Well, okay, let's.
Why was
one,
it so loud?
One, dear God, they should just hire us, the prosecution, the state to do that because it was so bad. Like, I literally got a headache from how, and like my volume, by the way, on my headphones right now is at 20%.
Mine's at
And it was
22.
I had a headache from it. Oh my gosh, it was awful. But like, what about them playing videos like that? Witness testimony clips in a closing. I've never seen that before. That seems like, you know, that's just surprising. I don't think I've ever seen that, and I'm surprised.
I mean, I guess if Lori
allowed?
has the same ability, then whatever. But
Sure, but they're supposed to make their own judgments from the testimony, right? And then if you bring up their video testimony and the closing arguments, it kind of adds some more validity bias to that witness.
That's true.
Especially when you're seeing and hearing it with your own eyes, as opposed to the prosecutor just being like, you remember so-and-so said this, right? I mean, don't get me wrong. It's a great tactic for the prosecution. I've never seen that before, ever. I think the state got away with a lot because Lori didn't know how to object. I think so too. I wonder if that's why that happened, because that's crazy to me. I expected her police video to be. I was told it was going to be played. I mean, she caused a big kerfuffle over it earlier this morning, about 20 minutes being played. So I don't know why the whole thing wasn't played, but I'm not upset about it because that audio.
It was
No,
admitted
thank
for
you.
appellate or something.
Right, appellate purposes. But they said Trina was planning on playing it, but she didn't. I don't know.
Agreed, Kelly.
It is Lori's fault she didn't have an attorney, but you know, it's what you get when you're a multi-dimensional time traveling deity. I'm sure one of her past lives invented law. So it's fine. She knows the universe's law, and that's all that matters. Actually, I'm just kidding. She probably doesn't know the laws of the universe. Oh, God, Trina, girl. You're killing me here.
At least we know Lori's will not be better, but will be more entertaining.
Definitely more entertaining. I mean, she can ramble too. I mean, the judge has to at least give her equal time no matter what, right?
No. She is absolutely.
Definitely think she's a legend in her own mind. I mean, she's a goddess. She worked through that somehow. She became immortal. For someone who's become immortal, she really wanted out of that death penalty in Idaho. So that's kind of funny. Don't really understand how that works, but okay, Lori. You know, the trial she was too crazy to be put to death for, but yet can represent herself in this trial. But I mean, don't get me wrong, I think she's a crazy bitch, but
I forgot that they named her. I'm nuts.
That's why they took the death penalty away from her, because both her and Chad were being charged with the death penalty. And then she did all this, you know, incompetency bullshit. And they took the death penalty off the table for her because of that, but left it for Chad. And then here, literally a year later, because her trial was, oh no, I'm sorry, her trial was first, and then Chad's was last year. So her Idaho trial was 2 years, but still, like, you don't just come back from that level of crazy to like represent yourself in a different, like, that's crazy.
Terry, you're a legend in all of our minds too.
Epic. Will they transfer her back to Idaho after 2 trials? You know, we were talking about that earlier. I don't really know. I would think yes, that what could happen, because I know that this can sometimes happen, is that Arizona would allow Idaho to take over because she's serving life there. So why not have her in the same place? Right. But like, so Idaho would get custody of her, but while she's spending the Arizona sentence, right? Because they don't want, let's say, I don't know what the sentencing is for this. I haven't bothered to look it up, but let's say hypothetically it's 10 years, right? And she's staying in Arizona jail. Okay. And she gets out in like 8 to 10. She's up, right? What if Idaho doesn't come and pick her up in time? You know, so you're better off, I think, sending her back to Idaho. But she would have to probably serve. I mean, she has life without parole anyway, but I don't know. I don't know how the semantics are going to go with all of that. I thought they took it off because of discovery issues. They took DP off the table. I could be wrong, because she wanted a speedy trial and they didn't have everything yet. I could be wrong. I mean, it was 2 years ago, but I know that they delayed her speedy trial a lot because of her mental capacities. But I thought that her mental health was why it was actually taken off the table, because I think that's like a factor into the death penalty, but I don't know. You guys all let me know. That's fine. Too bad she's gonna be cellmates with Jodi Arias. Oh my God. Could you imagine? Ugh. Oh, so Belle says, yeah, that's right. Okay. I'm sure it's like multi-factors, of course. I'm just saying, I think it's very, very interesting, you know, because I mean, Idaho fought for that death penalty to keep it on the table, you know. Chad got it for a reason. Like they weren't messing around. So I don't know. There were some problems with discovery. So, okay, so she asked for a speedy trial, but Chad didn't. Is that why that a speedy trial discovery thing would play more into her trial as opposed to Chad's? Is that what you guys are laying down there? Sorry, I'm so red in my face. Oh my gosh. I'm hot and sweating. It's a 4K camera. Let me tell you what, yikes. All right, what does Bubby say? Vallow's attorney said it would be taken off the table because they won't have time to fully review a large amount of evidence that was turned over. That sounds like a them problem if they asked for a speedy trial for a death penalty case, though. But, okay. I guess they got their ducks in a row for Chad, I guess. I mean, I'm not like upset about it. I just think it's interesting. It's interesting. I mean, just the fact that like they're her kids. Like, I feel like she definitely deserved the death penalty more than Chad. Well, they equally deserve it in my opinion, because their crimes are that brutal and that horrific and all that planning. Like, I would consider myself a pro-death penalty person, but in a very case-by-case basis, right? Because you can't say, oh, I don't believe in the death penalty except for in this one thing. You can't really do that. But the fact of she let that happen to her kids and allowed them to do what they did is irreprehensible to me. Oh, they were severed because she wanted a speedy trial and he didn't. Of course, she loves her speedy trials. And don't get me wrong, it's a really good tactic if you got a complicated case pressuring the state to do it as quick as possible. Like it's risky, but it can be a benefit. Miss Tedford, you say you're reading your oh, right on. Mm-hmm. It is a great bargaining chip for, you know, plea deals. You know, I mean, don't get me wrong. I know everyone has their opinions and they're all entitled to it, and that's super great. Oh, gosh. Why did my monitors keep going on and off?
I don't know. My you know, mine kept doing that. That's because of my settings. So.
I don't know. It was fine all day today, and then like in the last 2 minutes, it's like, oh, you want to speak? Okay, well, let's just flash on and off. So you have no idea what's happening. Wait, what? People can have their own opinions? I mean, everyone's entitled to their wrong opinion, sure.
I say that to Amy all the time.
Like, I mean, sure, you're entitled to your wrong opinion. I mean, that's great. I thought we all had to have llama opinions. Oh, that's boring. That's boring. Hey, that's my life.
It's okay to be wrong.
Buffy, how many times a day do you say, well, it's not great? Be honest, how many times do you find yourself saying that now on a regular basis? Well, how committed are you to doing this thing?
All the freaking time.
All the freaking time. Yeah. Yeah, it happens. Feel mesh.
Might be
Oh boy. Now I'm thinking, I don't know if they're going to have a verdict today.
I don't know. Is she even going to get through her closing argument today?
It should. Because
Yeah,
there should be another like hour and 45 minutes before the end of court, usually. We still have like another hour and 45 minutes for that. I
don't think they would be okay with her having the last.
Does Trina have a 3-hour rebuttal? We don't know. So.
Yeah, Kelly, I don't think so either.
Oops. I think they'll like initiate them into deliberating, right? Like pick who's going to be there, the altar. I think they'll do all that. They'll discuss their schedule and then they'll be back and be like, oh, by the way, the jury's going home tonight. So, which, like I said, you know, tomorrow we're doing Karen Reed over on True Crime and Wine Time, that YouTube channel. So go follow and subscribe there. We'll be covering the trial of Karen Reed. When the verdict comes in, we probably won't go to it live, but as soon as there's a break in the Karen Reed court, we will watch the verdict, you know, whatever it is, when it comes through tomorrow. So we'll see. Oh my goodness. Mama, check Discord. Mama, do this. Mama, do that. Mama. I'm just kidding. Just kidding. I don't know if that's what I'm supposed to be looking at, but okay. I'm just kidding. Calm
down, baby. Oh my goodness.
What do you guys think? What do you it made me think of Lori. Oh, okay. So that's fine. I'll tell everybody since you said that. So Terry sent a screenshot of this BBC History Magazine news article. The title says, she was paid to have sex with the devil, but there was something very strange about his penis. What does that mean? Oh gosh, can't wait to read that later. Right, because what Chad was called the storm.
Yes, he was. Oh my goodness.
I mean, if they all agree, they could get it done in an hour. The storm. Oh, they're back. Well, here we go. Our last chance was with Lori.
Seated. The jury is present.
Hear ye, hear ye.
The defendant can proceed with her closing argument.
Oh, sorry, this judge remembered we're in 2025, but okay.
Draw near and be close.
Please don't be boring, Lori. Please deliver.
Also, tell us how you're curling your hair in there.
Yeah, because seriously, her curls
Ladies and
stay
gentlemen
in
of the jury,
everything.
The state of Arizona has the 100% burden of proving that I committed a crime, a grievous crime,
which
conspiracy to commit premeditated murder of my husband, Charles Vallow. The state has the burden of proving to you that this event was not self-defense. In your jury instruction under the instruction, use of force and crime prevention, the last line reads, if the state fails to carry this burden, then you must find the defendant not guilty. In the law, under your jury instruction titled Justification for Defense of a Third Party, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty.
Ooh, I love when a non-lawyer
Under
tells
your
us how to
jury
interpret the
instruction
law.
titled Justification for Self-Defense, the last line reads, if the state fails to carry this burden, you must find the defendant not guilty. In your jury instruction, under presumption of innocence, it states, the law does not require the defendant to prove innocence. Every defendant is presumed by law to be innocent. Under the burden of proof, it explains that the state's burden is this. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. If, on the other hand, you think there's a real possibility
You're right.
that he is not guilty, you must give him the benefit of the doubt and find him not guilty. In Arizona, self-defense is defined as not being a crime. So let's look at what we've learned in this trial.
Look at that. Court reporters.
We learned that a shooting occurred
Searching.
and that 911 was called, that law enforcement was notified. We learned that fire, EMS, and Chandler police arrived at the scene. We learned that my brother, Alex Cox, came out of the house with his hands up as directed by 911 and was questioned by the police in the driveway. We learned that I came up with my daughter Tylee, and we were told to wait by the car until police would speak with us. We learned from Detective Inklin on the
That's
stand
everything right now.
that we asked for Tylee's medication from the house for her panic attacks, but it was not given to her. We learned that eventually my brother Alex was taken in a police car to the Chandler Police Department uncuffed. We learned in this trial that my daughter Tylee and I were also taken to Chandler Police Department in a police van. We heard from Detective Inklin's testimony that her goal was to make small talk with us. And
The jury will determine what the testimony did or did not show. Go ahead.
Objection 1.
that her goal was to make the small talk with us and all the way to the station so she could speak with us separately before we would talk about what actually happened. We learned that all three of us were separated and taken to 3 interview rooms where we each told police of the events of the day, each from our own perspectives, and answered all questions asked of us. We saw snippets of that interview in the trial here. The state did not show you the entire interview. Most of my police interview is admitted, though, into evidence in this exhibit. It's number 286. And I would encourage you to watch that entire interview when you start your deliberations. It is important. It is important for you to determine for yourselves my demeanor and not listen to anyone else. You can see it with your own eyes and hear it with your own ears.
We can, Lori. Thank you.
We heard from several witnesses that because this event was almost 6 years ago, that their memories of the events and statements were probably better back then. Well, my police interview happened that very morning, and I told the police the events from my perspective at that time. It is admitted into evidence and will answer many of your questions. You did not see Tylee's interview, but we did learn from Detective Inklin that she did an interview that morning as well. You did not see Alex's interview, but we learned that Alex was interviewed that morning by Detective Moffett, the original case agent, whom we did not hear from in this trial. The state chose not to show you those interviews or let you listen to the 911 call.
The jury shall disregard that last statement. Okay, the jury can only consider what was admitted into evidence.
We learned in this trial from Officer Kautheim's testimony that Alex was injured on the back of his head with a bump and, according to his testimony, a 1-inch laceration. We did not see those pictures documenting that injury as well. We learned in this trial that we did not know, the 3 of us, that our interviews were being recorded. We learned that Alex's phone was taken by police and put into an evidence bag, according to Detective Duncan, and that no digital copy of Alex's phone was taken by the Chandler Police Department, even though this is their normal protocol. We learned that Alex's phone was returned to him that same day with no further inquiries. We learned that after my interview and Tylee's interview that we were introduced to a victim's advocate and that gave us further instructions in another room where Tylee and I were reunited. We learned that soon after that, all three of us, Alex, Tylee, and myself, were taken in another van and dropped off back at our house. We learned that we were instructed at that time that we could not enter the house yet.
Actually, people are allowed
We
to
were
have jewelry in
directed by law
prison and stuff.
enforcement to take the rental car, since all three of our cars were inside the police tape.
Religious
We were
jewelry.
directed to return later in the afternoon when the scene was cleaned up.
At least here.
We learned in this trial that we did as directed and left the house in the rental car close to 12 p.m. We learned that we did not return to the house until contacted by Detective England to return to the house so that Alex could walk the detectives through what they call a walkthrough. We learned that many detectives were present during that walkthrough with Alex. We learned that Detective Duncan was there, Detective Coons was there, Detective Moffat was there, Detective Werther was there, and an officer with a body cam was there. And yet, we were told by Detective Duncan, the case agent on this case on the stand, that because of some problem, the walkthrough is not recorded. Detective Duncan also informed us that he does not know if any of the people present wrote a report about it. We can infer from Detective Duncan's testimony and the fact that we don't have an evidence, any body cam footage of the walkthrough and no reports talking about it, that there are none, even though this would be crucial evidence for you, the jury, to have.
Three.
Sustained. The jury should disregard that comment. Again, the jury
Should
can only
testify.
consider evidence that was admitted in the testimony.
Third rejection.
Testified, Lori.
I'm sorry, testimony that was admitted into evidence or exhibits that were admitted into evidence.
That, literally
The
everybody is
state of
dead.
Arizona has the obligation to show you evidence to prove that this event was not self-defense, as stated by the only three witnesses. So why not show the jury all the evidence that they gathered?
Again,
I need
sustained.
my nails. Can't do
The
that.
jury can only consider the evidence and testimony that was admitted into evidence.
We learned in this trial that Alex fully cooperated with law enforcement. We learned that my daughter Tylee fully cooperated with law enforcement. We learned that I fully cooperated with law enforcement. We learned that law enforcement treated all of us that day kindly and courteously on July 11th, 2019.
Great. Relevance.
A rejection
That law enforcement treated us that day like this was self-defense. We were not given instructions to stay in town. We were not given instructions that we were under investigation of any kind.
Would she have listened though, Buffy?
On July 11th, 2019, we were interviewed by Chandler Police and released with no further instructions. We learned that Chandler Police put out a press release that day on July 11th.
I'll sustain that objection to the extent the jury is to determine what the facts did or did not establish.
Thank you.
Solid.
Under Arizona law, I had the right to self-defense. Tylee had the right to self-defense. Alex had the right to self-defense. This event was not planned or expected. It was shocking.
I bet she brings up
in
the
this
second
trial,
gunshot.
the Chandler Police Department neglected to do a thorough investigation. We learned that they did not swab Alex's hands for gunpowder residue. We learned that they did not swab my hands for gunpowder residue. We learned that they did not swab Tylee's hands for gunpowder residue.
Which is a joke.
We learned that they did not luminol the gun. We learned that they did not luminol the bat. They did not test the DNA on the bat that they collected. They did not test the floorboard. They did not test the projectile. They did not test my husband's shirt. They did not search the rental car. They did not search any of our 3 cars that were there at the scene. They did not test the gun until over 5 years later.
Was there exculpatory evidence, Lori?
The Chandler Police Department did treat this event just like it was, self-defense and a tragic family event.
Tragic family event.
We learned in this trial that Charles and I were obviously having marital problems. Regardless of what was happening in our marriage at the time, on July 11th, this was self-defense. When Tylee came out with the bat to protect me, her mother, Charles did not have to take the bat from Tylee and start swinging. At 62 years old, Charles had a choice that day and could have put the bat down. A 2-minute period changed our lives forever.
Her face
How are
is
you
tragic.
supposed to choose between 3 people you love? Your husband, your daughter, your brother?
Agreed, Angie.
All right, hold on. All
6.
right. I'll caution the defendant not to testify
6.
about things that were not entered into evidence.
Should take him stand, B.
How can you decide for another person if they feel threatened? Why does the state want to blame to someone?
7.
I'm sure you'll point that out in rebuttal. I'll allow the argument as that inference. Go ahead.
Why does the state want to blame someone for this tragic event? What evidence did the state show you in this trial that I wanted harm to come to my husband? We learned in this trial that I was praying for my husband. We learned in this trial that even though my husband and I were having marital issues, that we were both trying to do the best things for our son with special needs, JJ. We learned in this trial that I was shocked that Charles had changed his life insurance policy, but I was not angry as the state alleges. In the phone call we heard from the insurance company, we heard that I was disappointed for our children, our grown children, as well as our children still at home, but I was not angry. My husband Charles was providing for our children still at home. I had no motive to change that.
Okay.
We heard a lot in this trial about the Book of Mormon prophet named Nephi. This is the state's evidence to murder over self-defense, and it is utterly ridiculous. We heard from Detective Duncan, who admitted on the stand that he had no idea what I meant in the text message when I said, "We will be like Nephi." In Mormon culture, Nephi signifies strong faith, perseverance, and courage.
Oh, please.
Sustained.
The state's attempt to misconstrue the positive text message about a wonderful religious figure, Nephi, and try to turn it into an order to kill someone is absurd.
Is it?
This is an attempt by the state to
are.
try to retrofit a crime that doesn't exist. This event was not a crime. It was a tragedy. Don't let them turn my family tragedy into a crime.
Yes.
When I'm done speaking to you, the state gets to get up and rebut all that I've told you. They've got to have the last word, so to speak, because it is 100% their burden to prove to you that I committed a crime. And you won't be allowed to hear from me again. So I want you to remember that it is the state's job to prove to you that I committed a crime. And if you have not seen the evidence that leaves you firmly convinced that I have committed this very crime, then the state failed to show you the evidence that you need. Because I did not commit this crime. The only interview the state entered into evidence is mine. So I encourage you to go watch it. I told you just what happened that day, just the way it happened. The state put forth a bunch of evidence in this trial in an effort to make you dislike me,
Let's
to
put
try to
that to my
attack my
chat.
character, so that you would just say guilty no matter what evidence they showed you. But only you get to decide. The state put up witnesses that had zero knowledge of a conspiracy. The state did not show you evidence of an agreement to commit murder. They showed you evidence of a family tragedy, and then they showed you the sad effects of a family torn apart because of that tragedy.
Bitch, please. Bitch, please.
I
Really thinks
counted
her own words
7.
and nonchalant.
All right.
I'm sorry,
The
Amos.
state does have the burden, so I have the right to open and close the argument. Do you want to
Can
give
you
a
please-
rebuttal close? Go ahead.
Can you please give a definition of nonchalant, please? Thank you.
Please have the rebuttal be less than 10 minutes.
Of Charles Vallow is not a family tragedy.
Come back with fire, Trina. Let's go.
There is nothing that you can say about shooting a man as he lay on the ground that you can try to construe in any way to make that a family tragedy. This case is about the defendant, not Alex Cox. Alex is involved in it because that is her co-conspirator. We are not here to determine his guilt,
And he's
albeit
dead.
it is quite obvious.
And he's dead.
This
And he's dead.
defendant wants you to just look at one piece, and she wants you to hope that there's
Nailed
only a person who will say, I heard the conspiracy. But what did you hear in every instruction?
I don't know
Is
how.
that you can look to other evidence to
Sorry.
show that. This defendant wants you to forget about her words and pretend that when she told her lover, her soon-to-be husband, we got rid of him, that he changed the life insurance before we got rid of him, that somehow means what? That they killed him. And he changed his life insurance before they killed him. What does that tell you? That tells you motive, and that tells you who did it. This defendant is one of those because she's writing it.
We can't do that yet. Here, Angie.
She wants you to pretend that when she is talking about Charles for months, acquiescing and agreeing to her brother killing him, having people tell her that it's wrong, having people know that they're planning for something.
Right? We can't pretend, read all the polls.
Those
All
words
the
don't mean exactly what they are. We got rid of him. This defendant. The state, of course, has the burden. And that's how it should be. But every one of those justification defenses falls short when you look at the conspiracy itself. When they got rid of him, they did it by planning it. There is no reason that Alex Cox came over to this defendant's house with a loaded gun and waited for Charles to come inside, held there by this defendant using the cell phone. That is conspiracy. That is planning. That is premeditated. You can absolutely watch that whole video. That's why the state included that for you. What you're going to see is that Lori Vallow doesn't cry. She is not truthful
Yeah,
as we've
guys, do
gone
that.
through. Her timeline is absolutely wrong. She tells the detectives it's quick, it's 12 minutes. She wants you to believe that the police could understand all of this that day. But what did you hear? Is that all the police could tell initially was that the timeline was off. And then they started learning that the physical evidence
seemed to be showing that Charles was executed on the floor, but they needed to see if the medical examiner agreed with them 2 days later. And then they needed to pull all those iCloud accounts, phone records, and go through terabytes of data to bring forth these things that you have now learned and hold. They interviewed these people who learned of the defendant's religious beliefs, that she was exalted, that she was celestial being, that she didn't have to repent. Of course she thought she was Nephi. We learned that the physical evidence on
Hand over to
Charles
Lori.
and at the scene show us that he was executed.
I should see her
And
stupid
every
face.
single one of those defenses that the defendant has asked you to look at, the state has met its burden. Because even if you somehow believe that Charles actually had that bat and it wasn't staged like the rest of the scene with the shoes and the lack of blood there, that second shot is not justified for self-defense, crime prevention, or third-party defense. Arizona law does not allow you to execute a man on the ground. The defendant wants you to believe she was shocked and surprised by this, and yet she goes wandering around, goes to Burger King, Walgreens, drops off her kid, comes back and jokes about her neighbors. Not one action of a person shocked, surprised. She wants you to feel bad for her daughter, Tylee. You saw her there. You heard from the detectives. She's also not shocked, crying, upset, worried. And you saw Alex. Same demeanor. Why? They've had 47 minutes to work it all out. Go through Charles's phone, figure out what they're going to say. They've talked on the phone twice in this time period. This case relies upon all of the investigation that the police did. That day, when they knew that timeline was wrong, that day when they started to understand that the physical evidence at the scene was staged and wrong and didn't match what the defendant was saying, and then all of the evidence after that, culminating when this defendant told the man that she married later that she was having an affair with, as many times as she wants to say Charles was my husband. She didn't want him as her husband. She wanted Chad Daybell. She wanted that life insurance policy, and yes, she was angry about it. And she said, we got rid of him. That is her confession to you. That is why she is guilty of conspiracy to commit first-degree murder. Thank you.
Good job, Trina. Way to wrap it up, girl.
All right.
And she just took notes for that rebuttal. I don't know if you guys all noticed. She just took notes on what Lori said, and that's what she does. So good job on the rebuttal.
Members of the jury, there are 14 of you. Only 12 of you can deliberate. At this time, we're going to choose the alternate jurors by random lot here.
Money. Yeah, that's
so
all.
We have our
we'll
scientific method here of random numbers. 14. Juror 14.
I don't feel like they shook them enough for my liking. He just rattled them.
Juror 5.
What, like a bingo machine.
I don't think
I saw a trial that they did that.
So,
what trial was it? Was it Rittenhouse?
To the alternates, if I don't see you again, I want to thank
like
you
a
for
ball
participating
cage.
in this process. The admonition still applies to you until we call you and tell you that it's been lifted. I have in the past had to have callback alternate jurors to testify or to deliberate when, for whatever reason, one of the jurors can't continue to deliberate, becomes sick, has a family emergency, etc. So you still could have to deliberate in this case. But again, if I don't see you again, I really do want to thank you for participating in this process. I know it might be somewhat of a disappointment to not deliberate right now, but we will keep you posted and we'll let you know if we need you. The remaining 12 jurors will retire to the jury room and begin your deliberations. First, we're going to swear in my staff.
Do you swear that you will take charge of this jury and protect their deliberations from all outside interference and communication? And when they have reached a verdict, you will bring them back into court without revealing their verdict to anyone, so help you God.
One drop goes off.
All right, to the jury.
Did I miss anything of importance? Sorry. I'm gonna go potty before they didn't say time or anything.
Nope. He just swore in his staff.
Rittenhouse called his own. That's true. He did.
He swore in his
You
staff.
mean I can't do my own investigation? No, I do think Rittenhouse pulled his own, but I feel like it was in like one of those bingo ball machines. It may not have been that case, but I definitely remember seeing that once. It's unforgettable.
The jury's no longer present in the courtroom. I've passed out proposed aggravation phase jury instructions. In the event that there is a verdict of guilt, the state elects to proceed with an aggravation phase of this trial. So I'll let the parties review that. It's not too long. Got it. All right, we'll be at recess until we hear from the jury.
Okay, well, thank you for no information on what to expect there. So that's fun for everybody. Oh boy. Oh boy, boy, boy. No, I'm not sure if it was or not. I just know it was wild. Oh, just go back there, right? Guilty. I know, right? Like what I do feel like that. So normally with the 30-minute delay and everything, there's about an hour and 15 minutes of what we've been doing for the last week with their schedule. So I don't know if they're letting them argue past that or I don't know. Usually the judge will tell them, like, listen, you have till 4:30. Let us know if you can't do it, and then we'll come tomorrow. So they might let them. I mean, gosh, we've done some trials before where, like, the verdict. There was one trial that verdict came in at like 11:30 at night or something like that. I don't remember which one it was, but I need a drink, girl. I am
That's nuts.
Already a glass and a half down already. It's happy hour, right? Oh, they cut the East Idaho feed, so that's fun. Okay. Just a second. Okay, that was a lot. Let's see, it's 3:45 Pacific time now. So yeah, so they have about like usually I guess it's 45 minutes, but they're going to give them a 30 to 60 minutes heads up. Then it's just a 5. Yeah, I saw 30 minutes. So if the verdict comes in, I saw that they're going to give family reporters all them 30 minutes to get there. And then instead of the 30-minute delay, it'll be a 5-minute delay. So as soon as you hear there's a verdict, we'll get it in 35 minutes from then. So let's see. Judge Bruce Schroeder of Kenosha County, Wisconsin, is known for using a raffle drum resembling a bingo spinner. Yeah. To randomly select alternate jurors. This method gained national attention during the Rittenhouse trial, the 2021 trial of Rittenhouse. Was it 2021? Oh my gosh. I have been watching trials for a really long time. You just saw on Twitter they let the jury go home. Okay, all right, I believe you. Kelly, what does Nate Eaton have to say about it? Is that what you're talking about? Like, is it on East Idaho News? I don't know what happened to my East Idaho tab. Oh, there it is. I love Nate. He's just so awesome. I just read that her and Chad still communicate. How? I wonder how. It's
Are
interesting.
they writing letters?
Let's see. 314 is his last update, which was just the jury was going for recess. Amos, look at us remembering after all the. I mean, they do start to like blur together after a while. Wakes up. It's over closings. I know, you guys. Like, that was. See, I wouldn't make a very good attorney, especially like, let's say I was to give closing arguments to Lori. Like, I would be so sarcastic and so snarky. Like, I would, the jury would, that's probably why she was so calm and put together, because the jury probably wouldn't like it if I would do it, but I would just be like, in your face, Lori, the whole time. I mean, LLP will tell you, like, you don't want to get into an argument with me because I argue very lawyery. It's not great. It's not great.
Just kidding.
Huh?
It's mean.
It's mean. He says, he's like, it's mean. It's just mean.
I'm just kidding.
Just kidding. Gigi reported it. Okay.
Yeah.
Okay. No, they could. Gigi's there in person, so Gigi reported it.
Okay.
That's Gigi's there covering it, so that makes Gigi's from Pretty Lies and Alibis, so that makes sense. I know they could deliver. Come on, can we just try it for 45 minutes and just take an initial vote? 3-way phone calls. Oh yeah, that's true. I guess they could do that from jail. Ugh. Could you? Who's facilitating that phone call? Because you know they're having weird portal. Or Chad's
about
reading some of his cool romance novel stories. Gross. Oh, my tongue's a weird color. Don't look at it.
Ew, I hate that. I don't like thinking about that at all.
It's true. I'd rather think about my gross tongue right now than whatever Chad romance she has to spew. Fucking weird and gross.
Ugh.
It's like a 13-year-old's journal. It's something else. Judge Schroeder retired. That makes sense. I mean, we all saw him. Oh, goodness. Okay. Well, you know, I mean, the jury probably made the right decision, right? Okay. We're all like, yeah, it can't be that hard. But at least they are. That tells you that the jury is taking their duty responsibly, right? By being like, listen, we're going to go home and think about it. Is it annoying to us? Yes, it is very annoying. But, you know, it does show that they're taking it seriously, which is all we ask for out of a jury. So respect where respect is due. I mean, that's, you know, disappointing. I was wrong about that, but I also, Trina lied about how long her freaking closing argument was. So rough. I'm trying to see. Maybe they want to make Lori sweat. They just want another day of free lunch, right? Well, now I don't even know. Hold on. Let's see if they at least made a time of when the jury is supposed to come back tomorrow. Because normally they've been coming in at like 10, 11 o'clock because the courtroom is full, right? But they're just deliberating. So usually when that happens, they let them come in early. All right, Nate still hasn't updated on East Idaho News. Get it together, Nate. So maybe they come in at like 8, but either way, it looks like Eastern time. We probably won't get one. Well, if they discuss it reasonably, we might actually get a verdict. If Karen Reed's ends when y'all say it usually does, and the jury takes a couple hours, we might actually, and they're delayed coming in, we might actually have a verdict after Karen Reed tomorrow. Time now. Oh, goodness. Let's see. Maybe they want to make, oh, we already did that one. Oh, well, I would say until lunch is over. Now, see, do they buy them all lunch, right? Because I got selected to, well, I had to show up for jury duty once for a whole week. I never got called for voir dire. We were responsible for our own lunch. So that was great. But you know what was nice is like you wear this little like juror badge and they're like, nobody's allowed to talk to you. If anybody talks to you, you come tell us. And I was like, okay. And guess what? Nobody will even look at you. You're like invisible. All right. Nobody will make eye contact with you at all. It's pretty awesome.
I need one of those for every day.
I know, right? Like, ooh,
Like
this is
public.
like literally would not even make eye contact with you at all. At all. It says the jury will return tomorrow. Well, what a cliffhanger, you guys. I'm assuming, yeah, they pay once you've gotten selected, but like, do they order from somewhere? Or is it like courthouse cafeteria food? Ours has a cafeteria, but I've never been. They only buy you lunch once you're on the actual jury. Well, it's nice since they pay you like $4 an hour or whatever. Ooh, oh, that's right. Buffy was on the jury. Maybe over on Couch Court during one of our breaks, Buffy can tell you about her jury experience. She served on a jury. So they order out. I mean, that'd be smarter than taking people out. But, you know, sometimes you got to get the jurors out of the courthouse every once in a while. Some courts bend over backwards for jurors. Did you hear what all they did for Richard Allen's jury? They took them on like all sorts of trips and things. They treated them real well. Oh, you were sequestered? Ooh. Was that nice though? I don't think I would hate being sequestered. I mean, they put you up in a nice hotel. Can't talk to my family for how? Okay. Fine. Can use a vacation. That kept you in. So we've had 3 people serve. How many of y'all have served on a jury? So far, that's 3. I only got called once in my like 20 years of living here. It's very disappointing. Just 2 nights, so it wasn't that bad, but still not great. Okay, why was the hotel not great? Because I think that's probably the deciding factor for me. And I send my mother-in-law to be sequestered. I mean, maybe. Triple homicide. My first. Oh, geez, that's a tough one. That's a tough one. I figure everyone's probably just super tired today and was just like, all right, this is training.
Well done.
Should have had a little bit more energy. Get them fired up to want to go back there and check a box. I don't know much about jury consulting, but I feel like I would be good at it.
I think so.
Thanks. We call it homicide prevention. Oh, that's fine. Well, yeah, I would love to for you to share your story sometime. That would be amazing. So come to Discord for the scoop. That's right. You can join our Discord. Somewhere. There it is. Hold on. Get rid of that. There you go. That's the Courtyard there. Just / the Courtyard is where I like to hang out. Well, you guys, guess we're done early today. As I said, we will no longer be having court streams here on this YouTube. Please join us over at True Crime and Wine Time. Let me show you what the page looks like, so you guys know you are in the right place somehow, however my things work. But so we decided we're going to be covering the Karen Reed trial there in what we're now calling Couch Court with Llama and Friends. So we will be over there at 8:30 in the morning tomorrow to start Karen Reed, which you'll see a lot of Annie there too. Neither one of us. Unfortunately, whatever.
Unfortunate for you guys.
Unfortunately for you guys. Yeah, so this little YouTube channel right here, boom, right there. You can click the subscribe button, all right, and join and become a member. And we'll be there tomorrow morning, bright and early for Karen Reed. Oh, because we're crazy. Because we're crazy. On that note, have you said what thumbnail? Nope, that is coming as soon as we're done here. So I hope you join us, Kelly. I think it'll be great. I mean, we'll laugh. You know us. We're silly. We just like to have a good time. We're not trying to be too serious. I mean, we'll be serious when we need to be serious, of course, right? It's real life, real people, real consequences. So we will be serious when we need to be serious. But like, if you all know me, you know I can like not have fun. So I do promise it'll be great. So buckle up. Yes. You're not doing Karen Reed? Oh, come on, ladies. What about with us? We haven't seen it. You never know. Oh, please get that thumbnail out there so we can share it. Yes, ma'am. It will be coming promptly here within the next hour or two, I promise.
Mama
Okay?
do.
Mama do. All right, you guys. Well, we're going to go ahead and call it a night. Annie, you got anything else you want to say?
Nope. Just join us tomorrow and we'll have a good night.
It's a whole lot of drama, and this llama is going to spill it. But all right,
It's
y'all have a great
banana.
night. Remember, tomorrow morning, True Crime and Wine Time, YouTube channel. Be there. All right, bye, guys. Have a great night.
Bye.
Bye.